Good morning, everyone. Please be seated.
Good morning, Your Honor.
Give me just a moment, Ms. Eats. Situated. What's going on up here? Ms. Eats, if you introduce the case, please.
Yes, Your Honor. We're here on the matter of the State of Washington versus Jeffrey Allen Nelson, cause number 20-106432-3, Kent designation. The defendant is present, represented by his counsel, Tim Leary, Emma Scanlon, and Kristen Murray. State is present, represented by Patty Eakes and Angelo Calfo, Special Deputy Prosecuting Attorneys, and Ian Ith, Senior Deputy Prosecuting Attorney from the King County Prosecutor's Office. We're here for sentencing in this matter, Your Honor.
Okay, thank you. All right, good morning, everyone. Before we begin, I want to go over a few ground rules and lay out what everyone should expect. I want to start by addressing those who are appearing via my Zoom platform or my Zoom courtroom. I want to remind you that while you are here via Zoom, you still remain a part of my courtroom. Therefore, I am expecting you to govern yourself as you would if you were here in person, to be respectful of one another, to keep naming conventions neutral. You can use your name, you can use observer, but to keep all identification neutral, that you mute yourself at all times so that we don't have issues with feedback. The chat feature has been disengaged, although if you are having some issues, you can reach out to the court, meaning Ms. Doris, my bailiff, will see that chat if you are having issues, but we will not allow you to chat with one another via this or put comments via the Zoom platform. We are here today for sentencing on defendant Jeffrey Nelson, a jury having convicted him of one count of murder in the second degree and one count of assault in the first degree. It's been over a year, almost a year, since official pretrial proceedings began in this. So this has been a long time coming for many of the people in this room on both sides of the aisle. The family of Jesse Sarey, who lost Jesse in May 13th of 2019, and to the family, friends, and supporter of defendant Nelson, who have been awaiting the outcome of the charges that were filed in 2020 against him, and Mr. Nelson himself awaiting his fate. I say this to remind everyone that it is an emotional day for everyone that's involved here. And so I ask that you be respectful, that this is a place where we respect one another, where the court is here to hear everyone's voices, and that everyone's voices will be heard, but we will be respectful of one another's voices. We'll be respectful of differences of opinions. Any comments that are offered will be offered directly to the court and not to any other person. The process that we will engage here today is we have some preliminary motions that the court's going to hear argument on. And what those motions will start off with is the fact that the defense has filed a motion
Lost your audio. Can't hear you on the mic, Your Honor. There we go.
Okay, move that up closer. There we go. All right. So, a motion asking the court, based on legal grounds, to vacate count 2, which is the assault charge. The court's going to hear argument from both counsel on both sides on that for, well, approximately a half an hour. I've given the attorneys up to 15 minutes to present each. From there, we will then move into the prosecution's presentation on their sentencing recommendations.
Lost again.
Yeah, it's going in and out. I don't know why. Okay, thank you, Ms. Michelle. All right. We will hear from the prosecution, where I believe there are 4 family members who have been identified to speak. We will then take a brief recess. During the recess, I am reminding you that during the recess, again, we'll have a large number of people who are exiting the courtroom. To try and alleviate congestion, I will probably release you in sections. I would ask that you not congregate in large groups in the foyer. It's not raining outside, it's a beautiful day, so please go out, get some fresh air. Don't congregate in this large area. That will reduce hopefully any tensions that could flare up during that time. We'll take about a 15-minute recess for that. When we resume, then we will hear from the defense on their presentation. I believe they've identified 4 people who will be speaking as well. After which, the court will render its decision on the issues that are before it, including whether or not the counts merge and the defense request for a departure from the standard range. Let me, at this point in time, take a moment to explain what the court has received and reviewed. The court has received and reviewed the prosecuting attorney's standard sentencing material packet, defense's sentencing recommendation, which included a request for an exceptional sentence deviating from the standard range. It also include letters of support for defendant Nelson, which I'll tell you who I received in a moment. I received the state's response to the defendant's request for an exceptional sentence with 2 additional exhibits A and B. Defense's reply in support of the exceptional sentence with 2 additional letters in support of defendant Nelson. The state's sentencing memorandum with exhibits A through D. Letters in support of Officer Nelson who were received from his law enforcement community or people associated with him are Alyssa Slate, Brian Anderson Jr., Brittany Berger, his neighbor, Doug Johnson, Matt Wilkerson, Kenny Lyman, Terry and Jeff Morford, Chris Boldman, Stephanie Lyman, Gloria Biles, a city employee, Susan Van Slyke, a Auburn Police Department employee, Derek Anderson, Andrew Bryant, Christopher Powell, and David Lynn. Yesterday, late in the afternoon, the prosecutor's office also filed letters from community members in support of the prosecution's position on this case. Those letters from community members included letters from Mimi Hawkins, a friend of Jesse, an unnamed community member, Garth Donald, Kaman Vo, who was Jesse's teacher and tutor, Alyssa Thomas, who was a community member who lost her child, she said, at the hands of the police. Please Batista, who's also a community member. Kanina, an Auburn community member. Joe Cheerlin, a social services worker who knew Jesse through providing services for him. Leslie Crushman, Trishanda Pickup, who was a community member. Garth Donald, Stephen Woodard, who was a witness in this case, Debbie Norvac. As to the letters received by the community members, the court received them late yesterday and had indicated the court wasn't clear that the court was going to have an opportunity to review those. I actually did late last night have an opportunity to review those. I will be honest, some of them had lengthy attachments. I did not have, because of the lateness, I did not have the opportunity to review those lengthy attachments. But prior to that, I did tell the prosecution that they were free to refer to those materials and point out to the court anything that the court should be aware of that the court may not have had time to fully review or digest given how late the materials came in yesterday. I also, in this matter, received the defense motion to vacate the conviction for the assault in the second degree and the prosecutor's response to the defense motion to vacate the count 2, the assault in the first degree. Ms. Eakes, is there anything that you are aware of that the court should have received and reviewed that the court has not mentioned?
No, Your Honor, I believe that's complete.
Defense, is there anything that you believe that the court should have received and reviewed that the court did not mention?
No, Your Honor.
Okay. Then with that, I would like to now turn our attention to the defense's motion to vacate count 2. And who will be presenting? Will you be presenting?
I will, Your Honor, and because of sometimes my voice drops, I'm going to use the podium.
I'm gonna, and that's the other thing, when it comes time to speak, I'm gonna ask that people use the podium with the microphone.
Okay. And can the court hear me all right?
I can.
All right. Your Honor, as the defense laid out in its motion, the defense is moving to vacate the conviction for assault in the first degree, which is count 2 pursuant to double jeopardy. The state's opposition to this motion, which we did not have time to do a reply on, just given the short time frame, it basically boils down to an argument that this fight, which lasted about 30 seconds, included 2 separate assaults under the law. One assault for the first shot Officer Nelson fired, and one assault for the second shot that Officer Nelson fired. But under the law, assault is not defined by each separate act. The Washington Supreme Court has made that clear. They made that clear in the Villanueva Gonzalez case. That holding makes clear that assault is a course of conduct crime. And the court explained, for example, that the reason that they found that is that a defendant should not be convicted for every punch thrown in a fistfight. Acts that are part of a single course of conduct can only support one conviction. So the issue here, Your Honor, is whether Officer Nelson's actions constituted one continuous single course of conduct. And in order to determine that, you have to look at the Villanueva Gonzalez factors, which is the 5 factors that the Supreme Court laid out. Now, the state in its response argues that the defense reliance on that case is misplaced. They argue that it's misplaced because in that case, the court was looking at a unit of prosecution test, and that according to the state, that's not applicable to this analysis for double jeopardy. But cases have made very clear that the unit of prosecution analysis is relevant to the application of the same evidence or Blockberger test, and is therefore relevant to whether or not analyzing 2 convictions violate double jeopardy. And one of the cases cited by the state in its responsive briefing actually makes this clear, and that's in the matter of Knight.
Give me 1 second. Could you let them know if they wish, they can go up to the courtroom on 4D? Okay, thank you. We forgot to put a sign out there, so. Oh, good. Oh, my staff is amazing. Thank you. Okay.
So one of the cases cited by the state in its responsive briefing actually makes clear that unit of prosecution is part of the analysis for double jeopardy. That's in the matter of Knight. In that case, there was a fairly long discussion about what unit of prosecution for robbery was as part of their double jeopardy analysis. And the court specifically looked at the unit of prosecution for robbery when it was looking to determine if there was a double jeopardy violation with that defendant's convictions for robbery in the first degree and then felony murder where robbery was the predicate. So unit of prosecution and this case that we referenced in our briefing is very relevant. And the court has to look at that to determine here whether or not these 2 acts that the state says are separate, whether or not they constitute a single course of conduct. So
with the unit of prosecution and with the Villanueva case, we're both saying it wrong,
yeah.
but we know what we're talking about. The situation here being that, from the state's perspective, there were 2 separate incidents, and that the assault, meaning the first shot that we were informed by the witnesses was to the abdomen area, and the second to the head were 2 separate issues as opposed to being the predicate for the felony murder, and therefore it isn't applicable. So would you address that?
Yeah, so you have to look at the factors, right? So the first 3 factors, I think, are undisputed. The length of time over which the acts took place, everybody's agreeing this was a very short period of time. I don't think that that's disputed. This was seconds that we're talking about. Whether the acts occurred in the same location, absolutely undisputed. And then Officer Nelson's motive or intent for the acts, right? Because that's one of the factors you have to look at. Now, from the defense perspective, it's the same, right? Both shots were in self-defense. From the state's perspective, it's both shots were to inflict great bodily harm.
And so to that, then, that brings me to my next question. From the defense's perspective, they were in self-defense, but a jury has definitively found that there was no self-defense here.
Right, but even if you look at the state's theory or perspective about that factor, whether or not the motive or intent for the acts was the same, it's the same. Their theory was that he was intending to assault Mr. Sarey for both shots. So it's not different for that. Where the difference is and where the dispute really is the fourth and fifth factors, which you consider together, right? Whether or not there were acts that interrupted or intervening acts that interrupted the actions, and then whether there was an opportunity for Officer Nelson to reconsider his actions.
So when you look at this situation and you look at it in terms of what we all know, which is when you're looking at something that we don't have here, which is like a first-degree murder case, and we know that the courts have all agreed that when you're looking at the issue of first-degree murder and whether or not it was forethought, that there is no time stamp for that it can be short, it can be long.
Sure.
And the cases are all the way from milliseconds to days. We've both seen cases like that. And so when you take that into consideration, why, given that we know from the evidence that then Officer Nelson, now Defendant Nelson, had the opportunity to stop, clear his gun, look around, and then aim to take the second shot, which was straight to the head. When you look at that in this context, why shouldn't the court find that there was an interruption such that these should be two separate acts and that there was an opportunity for him to reconsider his position?
Because there wasn't time, Your Honor. So just first as an initial matter, in the state's briefing and throughout their sentencing materials, the state has repeatedly said, which was their theory at trial, that Mr. Sarey fell right away to the ground and was incapacitated. And that's not what the evidence showed. That's not what the video showed. We had tons of testimony.
But wasn't that also, that was one of the issues that was actually highly disputed?
It was. It absolutely was. And the state's own expert conceded that, right? That there was movement between those two shots. So really what we're looking at is not just that 30 seconds, right? Where it's from the time that Mr. Sarey stood up to the time the second shot is fired is about 30 seconds. What we're looking at is that 3.44 seconds between shot one and shot two. So given how fast all this occurred, there's just simply no time to say that Officer Nelson reconsidered his actions. Now, one of the things that I came across yesterday when preparing for this, and I would have put this in a reply if I'd had time to do it, is this case In re White. And just for the record, I'll cite what the site is. It's 1 Win App Second 788. It's a Division I case from 2017. One thing that case looked at when it was looking specifically at these factors is whether there was a moment of calm, a moment or an opportunity to reconsider. When they were looking at that factor, they characterized it as a moment of calm. Here, Officer Nelson believed he was in a fight for his life. And in the middle of that fight, his gun failed. Now, any police officer will tell you that it is an incredibly dangerous and scary situation to be in. It is for anyone, just any citizen that's in that kind of situation. There is nothing calm about it. You are doing everything you can to get your gun back in the fight. And that's what happened here. Now, the state focuses on the fact, as the court mentioned, that when clearing the malfunction, Officer Nelson looked briefly at Mr. Woodard. And in his statement, he said he did that to make sure that Mr. Woodard didn't run into danger when he fired his shot. But the other thing the court has to consider, that as part of pretrial motions, the court heard testimony from our defense expert, Dr. Steve James. And he reviewed a copy of his report. The focus of his research was use of force decision-making and human performance factors. And he made clear that it takes time for the brain to process information. You have to assess a threat, understand what that is, process what it is, identify it, decide what to do, and then act. If we're talking about 3 seconds, there's just simply no time for Officer Nelson to have had the opportunity to reconsider his action. This was one continuous struggle, and you can see that on the video. His actions constitute a single course of conduct, and because of that, Your Honor, separate convictions for each shot that Officer Nelson filed under the Under the facts of this case,
Want some water?
I do. I'm on a lot of Sudafed right now.
It's going around. I've had sick people in my courtroom literally all week. It's going around.
So this was one continuous struggle, Your Honor. It constitutes a single course of conduct under the law when you look at the specific acts of this case, and because of that, separate convictions cannot stand. Now, the merger doctrine is what remedies the double jeopardy violation, particularly when you have a situation where the state has alleged there's an assault that is the predicate of the felony murder, and then another assault. Now, the state's trying to argue that the felony murder assault finished or completed before the second shot, which is the second assault. But if you look at this as a single course of conduct, the two must merge, otherwise, and the assault has to be vacated, otherwise you're going to have a double jeopardy problem. And that's why we filed this motion, Your Honor.
Okay. And I think you, in your brief, also mentioned, and I think we're all on the same page, that if there isn't a merger, there isn't a double jeopardy per the case law.
Well,
At least I found a case, and I apologize, I left it back in.
That's okay.
Yeah.
Yeah, I think double jeopardy and merger are slightly different. Merger doctrine is part of double jeopardy analysis. But in the circumstances of this, we would argue that it's a double jeopardy violation for both counts to stand. That under these circumstances, it would merge, the assault would merge into the felony murder, and the assault has to go away, because if both convictions stand, it violates double jeopardy.
Okay, all right, thank you.
Your Honor.
Mr. Kaufel, could you address the issue about the fourth factor as mentioned by Ms. Murray, in addition to anything else that you wanted to point out?
Your Honor, I will do that, and I think it might be, and I'm just going to step back for a second, if it's all right with the court, to just explain the state's theory on how the court should analyze this.
It's your time, you can
Thank
use
you.
it as you wish.
Your Honor, the state respectfully submits that the defendant was properly convicted of both of these charges. The criminal conduct in counts 1 and 2, in the state's view, relate to two separate circumstances and two acts. There's no double jeopardy issue here, and the court should deny the motion. Now, Your Honor, there's discussion in the briefing and in the defense argument today about what test the court should apply. I want to make it clear that from the state's perspective, it doesn't matter. They all, in a sense, are looking at the same issue. Was this two separate acts or not? I think when we're analyzing this, Your Honor, in order to do it in accordance with the case law, what the cases appear to say is the court should look to the way the state presented the evidence to the jury. The defendant is convicted now. The defense theory of the case, in a sense, has become opaque, let's say. And
I think that when I was doing some research, and there is, and you've cited one case, but there's a newer case out that also talks about, and I apologize, I literally, with everything I had going on, I left my research paper back, but there's a newer case, and if parties want, I can definitely step off and get that cite for you all, that discusses that in these situations, it gets to the point that you made, that in these situations, when the state elects either in the way something is filed or a way that it's argued, that can clarify that it's clarified for the jury whether or not the state's theory is a continuous act and which one thing is predicated on the other, or if there's separate acts. And if my memory serves, I think that's a case that came out like 2021, and I will find that site. I left my
Well,
research.
Your Honor, I actually have, in my prepared remarks, I quote from the Knight case, which says, "No double jeopardy where the state makes an election at closing argument that clearly identifies the particular acts on which charges are based. Verbally telling the jury of the election is sufficient to address any double jeopardy concerns." And I think,
A newer case that quoted Knight as well, yes.
and so, I mean, I don't think there can be any doubt here that when the state presented this case to the jury, it told them that it was basing one charge, count 1, on the initial shot during which there was a physical struggle, and it was basing the assault charge on the second shot, which occurred after that first shot and after the initial struggle. But, so if you're looking at it from the perspective of what Knight says, and you're looking at it from the manner in which the state presented this case to the jury, we don't think there is a serious argument that there's a double jeopardy problem here. And I think going back to what the court's initial question was, let's take a look at the facts and circumstances of each shot as they were presented by the state. The first shot was made in connection with a physical struggle that the defendant initiated. It occurred after the defendant failed to follow his training, as the state had presented, on the issue of time, distance, and cover. And I note that because it's a different lack of reasonable conduct by the defendant than the second shot, which I'll get to. So he didn't follow time, distance, and cover, and other aspects of his training. The shot was to his torso, and it's the one that resulted in his death. And it occurred while Mr. Sarey was pinned up against that ice box when he shot him in the torso. And so that is, those are, the key facts relating to count one that we presented to the jury. And we said, jury, based on those facts, you should find the defendant guilty of murder. And then there was, the 3.5 seconds, Your Honor, right? Now, 3.5 seconds in the abstract doesn't sound like a lot of time. But I think when we went to the jury, the court might remember, I sort of hit my hand against my palm and said 1 1,000, 2 1,000, 3 1,000 and a half. That's not an insignificant time for a trained police officer to make a decision. We know that. So let's look at the second shot. It occurred after Mr. Sarey fell directly to the pavement. We can see on the video how quickly he fell. The witnesses, in particular Mr. Woodard, and the video, you see that Mr. Sarey is essentially incapacitated. Mr. Woodard described him as looking as though he were dying. He was falling away from the defendant. He was moving. I think Ms. Murray's correct. But he wasn't. The evidence was he was moving away from the defendant at the time of the shot. His head was 7 feet. Mr. Sarey's head was 7 feet away from Mr. Nelson's when that second shot was fired. Mr. Nelson had to aim his gun as Mr. Sarey was falling away and shot him in the head when Mr. Sarey was not a threat of any kind. That's the way the state presented this case to the jury. And I think it's really important that his gun jammed, Your Honor, after the first shot, because that is a separation between the first and second shot. This wasn't a case where somebody was shooting somebody with a weapon that was automatic, for example, and it was just pow, 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 or a series of fist fights, a series of punches, excuse me. That's not this case. His gun jammed, and he was trained, and I think this is an important point. Tap, rack, and assess. Your Honor will remember, Mr. Haug said this, we argued it to the jury. He is trained to make a decision about whether it is morally or ethically right to shoot a second time. Those are words from the former Auburn Police Department officer, Tyler Christian. Was it illegal? You have to make a decision with each shot, particularly after the gun is jammed, and you tap, rack, and assess. Is it morally and ethically the right thing to do to shoot again? And he made that decision. And that's the basis of count two. He reloaded his weapon and he fired, Your Honor. He scanned the scene. He looked at Mr. Woodard. We can see that on the video. These are two different circumstances, two different factual scenarios. And the jury's verdict confirms this, Your Honor. The jury came back, as we know from the communications they made with the court. They found the defendant guilty of count two first. They understood that the state made an election at closing argument, and they found him guilty of count two first. They deliberated further, and recognizing the election that the state made, they found him guilty of count one. So, Your Honor, you can look at this under the unit of prosecution test. You can look at it under the same evidence test under Blockberger. You can look at it under the merger cases. When you go over those facts as to each different scenario, the defense argument falls apart. And that's why we think that the court should deny the motion. Just briefly, when you look at the Villanueva factors, and remember, Your Honor, Villanueva involved two separate acts, allegedly, that were charged under the same statute. This wasn't. That's why we think Blockberger applies. Because one charge was murder in the second degree, one was assault. But even if you look at Villanueva, we think factors 1, 3, 4, and 5 all are in favor of the state's position. 1, for the reasons I mentioned, it was a short period of time, but it was 3.5 seconds that a trained officer had to make a decision about whether to shoot again. 3, the defendant's intent or motivation to act. The first one was during the struggle. The second one, I mean, a lot of people look at that video and say, Your Honor, that this was an execution. It looks like the defendant is falling away. There's no danger to the officer, and he shoots again. What were his motivations? I think they were different for count 1 than they were for count 2.
And Mr. Calvo, remind me if you remember, and I apologize, I literally thought about this literally in the middle of the night. And I was trying to find it, but as everyone knows, we have so many reams of paper, I could not find it. But what I thought about in the middle of the night that I could not find this morning was, and if I'm incorrect in my memory, didn't Mr. Woodard at some point even say something like you shot him in the head or something, like recognizing? I know Mr. Woodard at the beginning was, and I can't remember if it was Mr. Woodard or the other eyewitness described it as Tasmanian devils because during the initial fight.
Yes, Your Honor.
But please, if you remember or if you think that the court's recollection is incorrect in this, and I will give you, Ms. Murray, the opportunity to respond to this as well. I was trying to find in my notes and in the witness interviews, did Mr. Woodard at some point in time, at the time of the second, at the time around either the second shot happened, so in the video, or in his recollection say something like he shot him in the head, so like he, acknowledging that there was a second incident that happened that he felt, and this is before he had any contact with anybody else.
Yes,
Do
Your
you
Honor.
recall this, and is my memory correct in remembering something along those lines?
Yes, Your Honor. He did testify along those lines, and there were a couple of ways in which that came out. One was the manner in which, remember, he demonstrated how Mr. Sarey looked when he was lying on the ground and he got shot. And then in the video that was played to the jury, this was the statement that Mr. Woodard made after the shooting. He said, I don't know about that second shot. No.
That's what I was remembering.
Yeah, I mean, he recognized the difference between the two acts, like the jury did, Your Honor, and like the prosecution argued to the jury.
And can you remind me, did he say that in the video, or was it when he initially spoke to the police officers?
Well, the video was it was a statement that was given by Mr. Woodard to Officer Benavente right after the incident.
And that's what I was trying to clarify, because we know Mr. Woodard had several, and that there was some concern about some of them happening after he had had other influence. But he made at the scene, and then the very next day, I think it was, is that the one that you're talking about, the very next day when he said, I don't know?
He made the statement relating to Mr. Sarey laying on the ground sometime after the incident to Federal Way police officers, as I recall. The statement that he made where he said, I don't know about that second shot, was immediately after the incident when he was videotaped.
That's what I was trying to find. Okay, thank you. And I literally, I apologize, I could not find, I was trying to find it. So obviously, Ms. Murray will give you an opportunity to respond to that as well.
So, Your Honor, we went over 3, which was defendant's intent. The fourth one is whether the acts were interrupted or whether there were intervening acts, and we've gone over that in terms of Mr. Sarey falling to the ground, falling away from the defendant's gun jamming, the defendant making the decision to reload the gun and fire. And the last one was the opportunity for the defendant to reconsider his actions, and of course, he was trained to reconsider his actions. He did, and he shot anyway. So I think, again, the point only being, we don't think Villanueva actually applies here. We think the same evidence test applies, but it doesn't matter, and we made that clear in our briefs, Your Honor. So, Your Honor, for these reasons, we're going to ask the court, we do ask the court to deny the motion. We think these charges were separate. They were presented as separate to the jury. The facts and circumstances show they were separate. The jury's verdict shows they were separate. Thank you.
Thank you. Ms. Murray? And what's the cite on White again?
Let's see. I actually have a copy of it if the court wants me to hand it
That
up.
would be great.
And just for the record, that site is 1 Winamp 2nd, 788, 2017, from Division 1.
Okay. I have it, Ms. Doris. Ms. Doris, I'm good. Oh, you want to read it? Okay, okay.
Okay. So just briefly, Your Honor, in response, the state's arguments is that the manner in which they presented it ensures that there's no double jeopardy violation, that they made clear to the jury what evidence pertained to which count. Now, to be clear, while they keep saying that the evidence was different, this was one video, same witness, same video for both counts, same witnesses for both counts, same medical examiner for both counts, which I believe, and the court will have to rely on its memory, but during his testimony said that both shots contributed to Mr. Sarey's death. And I think that's important. But while the state may bring multiple charges, and the jury may consider multiple charges for the same conduct, double jeopardy does not allow those convictions to stand if it is the same conduct. And that's why you have to look at the Villanueva-Gonzalez case, Your Honor. I do think that even the Knight case, when you look at it, the Knight case has this discussion about the manner in which the state presented, but before that is a very lengthy discussion about unit of prosecution for the robbery. So that is absolutely relevant here. The state talked about how the third factor, intent and motivation, weighs towards going with the state, that double jeopardy is not violated here. And they talk about how the intent for the second shot was execution, but that's not how the state charged this. The state charged this, both shots, as an underlying assault with the intent to commit bodily harm. And the only reason count 1 is charged as felony murder is because the assault is what elevated it. So they are both assaults. Both of the shots they are alleging, the intent was the assault and intent to commit great bodily harm. So the intent is the same. Now, Mr. Woodard, using his statements, Your Honor, to find that these were two separate acts is problematic. Mr. Woodard has given a lot of statements in this case, even on the day of. But if the court remembers, even the day of, his memory of things was not completely accurate, right? For example, he has always believed that Mr. Sarey was on the ground at the time of the first shot, and that is not the case. The video here is important because the video is what shows this is one continuous incident that lasts a very short period of time and shows that this is a single course of conduct.
Okay, thank you. All right. When we take a break, I'm going to look at White, and then I may give you all a quick second before I roll to come back on that, but I want to keep us moving at this point in time because we've got a lot to do. So with that, I am going to turn the floor over to the state to begin your presentation regarding your sentence recommendation, and in doing so, if you choose to also discuss, which I assume you will, why you are asking the court not to endorse the defense's position requesting a exceptional sentence downward.
Thank you. Mr. Ith is initially going to introduce just the mechanics of it, so to speak.
Okay, thank you.
Good morning, Your Honor. My name is Ian Eath. I'm a senior deputy prosecutor. I'm just going to very briefly summarize the sentencing recommendation, including the standard ranges and that sort of thing.
Nice to
And then
meet
I'll turn-
you. I saw your name on the documents, and I was like, oh, that's a new name, so nice to meet you.
Yeah, thank you. Your Honor, on June 27th, 2024, a jury found Mr. Nelson guilty of 2 counts, murder in the second degree and assault in the first degree. Both offenses are Class A felonies with maximum terms of life imprisonment and a $50,000 fine. The state agrees that Mr. Nelson has an offender score of 0 on each count and that the terms of each count should run concurrently. The seriousness level of second-degree murder is 14, resulting in a standard range of 123 to 220 months. The seriousness level of first-degree assault is 12, resulting in a standard range of 93 to 123 months. The state recommends that this court impose 220 months on count 1 and 123 months on count 2 to run concurrently. In addition, each count requires 36 months of community custody to run concurrently. The state asked this court to order restitution in an amount to be determined in a future hearing, and we asked this court to inquire of the defense whether Mr. Nelson would waive his right to be present at that future hearing. The state asked this court to impose a $500 victim penalty assessment because Mr. Nelson has not demonstrated his indigence. However, our written recommendation asks for a $100 DNA fee, and I'm informed that that is no longer applicable, so we're not seeking that fee. Because both convictions are serious violent offenses, firearm registration is mandatory in this case. And finally, Your Honor, the state asks that the court impose no contact orders for the maximum term of life, protecting Elaine Simons, Matthew Sarey, and Stephen Woodard. I'll now let Ms. Eakes address the reasons for our recommendation.
All right. There was one name that you mentioned, and I'm sorry, it escapes me. Matthew Simons?
Matthew Sarey.
Matthew Sarey. That is, I don't recall seeing, I know he is obviously related to Jesse. Could you explain the relationship there?
He's his brother, Your Honor.
And is that and is the brother going to be appearing via Zoom today? Okay, all right.
Thank you very much. And good morning, Your Honor.
Good
Thank you very
morning.
much. I'll try to keep my remarks somewhat brief because I know that this court knows this case probably just as well as the parties do. You've spent 5+ years handling this case, and you've obviously seen almost all, I'd say probably all of the evidence and all of the background related to the case. But before I, talk about Mr. Nelson, which is obviously the reason that we're here with respect to what's the appropriate sentence, I do want to talk a little bit about Jesse Sarey, because it always strikes me that in murder cases, and it's been a while since I've done, been a prosecutor, but that, the cases are always about the defendant's conduct, and there's very little that the jury or this court really hears about Jesse Sarey. So I just think that it's important for purposes of sentencing that we acknowledge him and that I kind of highlight and let the court know some things about him. First of all, you are going to hear from a few people related that knew Jesse, his two brothers, Colton and Matthew, as well as his foster sister and Elaine Simons, who is his foster mother. So you'll hear from all of them in a moment, and they'll tell you obviously a lot more than I can about who Jesse really was. But I'm glad to hear that the court did have time, and I apologize for how late the information came in, but that you were able to look at the letters that came from the community and from some people who knew Jesse. Because as I read them, a few things really kind of struck me. I thought it was interesting that people talked about how his smile made people happy, that they appreciated that he was very appreciative whenever anybody showed him any sort of kindness, and that he had empathy for the less fortunate, especially in the circumstance that he was in, obviously. That's a pretty remarkable quality. And, just as you'll hear, how his family loved him. There's no question, I think, that, Jesse was on the margins of society. And, he came to this country as a refugee and with a family, and they struggled once they came here. And as a child, he was separated from his family. He was in the foster care system. And again, Elaine Simons, and you saw her testify, wants so much for people to understand who Jesse is, and she's one of the few people that is able to do that now because there's been so much tragedy in the Sarey family. His mother, his brother, so many people who have passed away. But he struggled to find his way in society after he came here. And, as the court knows, he had mental health issues. Excuse me. And, like so many people, he was introduced to drugs and he became addicted. And, he didn't have a place to call his home. And I know that this court, because you've been a judge for a long time, can appreciate just how incredibly difficult it is for someone who is homeless. And I can only imagine, and I don't purport to really understand, what that does to somebody's mental health. And what it does to your day-to-day existence when you know that you don't have a place that you can kind of go and have refuge and be safe like the rest of us. And I say all of that, so I think that, it's good for the court just to kind of, and I know the court appreciates understanding a little bit about who he was, because we really didn't talk very much about Jesse in this trial, and we really haven't talked very much about Jesse throughout 5+ years of litigation. And like I said, the folks who will speak can really speak to him a lot more clearly than I can. But I think it's important to frame it. And the reason that I do that is because I think that as a lawyer, one of our core beliefs in our legal system is equal justice under the law. And that's inscribed on the U.S. Supreme Court building in Washington, D.C. And we most often think of it as a concept that applies to defendants, and that the concept being that no matter how powerful someone is, we apply equal justice to them. But I would just suggest that the belief in equal justice under the law also applies to victims. That equal justice under the law means that even those who are at the margins of society, who are mentally ill, who are addicted, that they're important people, and that they too have rights, and that they're entitled to protection of our laws. This concept of equal justice under the law is indeed probably the most critical for people who are on the margins of society. They need the protections that our laws are supposed to provide, because they are frankly the most vulnerable people in our society. And I think that is also, they can be the people that are most easily kind of cast aside, and the people that are easiest to abuse. And unfortunately, I think that, this court has heard so many times, so much information about what happened on May 31st, 2019. But that, I would suggest to the court, is exactly what did happen to Mr. Sarey. His life was devalued. The person that he was devalued by Defendant Nelson. And that's particularly tragic here when Defendant Nelson was someone who was trusted by our society to protect the rights of somebody like Mr. Sarey. There's no, and I know the court understands the import of what you will have to do today. And there really is no precedent here for sentence. And I know that, in the system, we often look at what's the appropriate sentence, and we look at other circumstances and other defendants who have been in those circumstances. And you don't have that precedent here. And that's simply because of the way our laws have been written, and the fact that we don't have officers who have been in this circumstance in which the law says we're going to hold you accountable in this particular circumstance, and that we're going to hold you accountable for unjust uses of force in society. But that's what this jury has done. Under a law, I-940, that I know the court is so familiar with, where the people of Washington spoke and said, we are going to hold police officers accountable in certain circumstances in a very, frankly, rational way. We're going to hold them to their training, and we're going to ask the question of whether or not it was a reasonable use of force, and whether or not there were other alternatives to the use of force. I think that, as the court knows, the state recommended a sentence at the top of the standard range here, and that is not a decision that was made lightly by the prosecutor's office. It was after debate among a number of people, and I want to explain to the court, I think, how the state came to that recommendation. You have to look at the fact that in some ways, you've got the fact that Nelson is the first police officer who is in this circumstance, and the court doesn't have any other guide to kind of look at. And maybe that, who knows where that comes out in terms of sentencing. But I think what's important here is that, unlike other defendants, he had training, and he had such superior knowledge, I guess I would say, compared to the ordinary person who might find themselves in this circumstance. And I think that the fact that he had so much training, and that he made so many choices to disregard what he had been trained to do, is really one of the critical factors from the state's perspective in terms of why the sentence recommendation was there. He was trained to deal with vulnerable people like Jesse Sarey. He had been trained to avoid violence when he was dealing with somebody like Jesse Sarey. But he just, every step of the way, as the court knows, disregarded his training on the day of May 31st. he didn't honor that rule that required him to kind of protect people like Sarey and his rights. And as I thought about what to say, I mean, I think the thing about this case that always struck me so much is that there just simply is no reason why Jesse had to lose his life that day. I mean, it's just, when you look at the grand scheme, and I know this court's been around a long time, and you think about the reason why Nelson ever made the decision to go contact him at the grocery store, is just baffling. I mean, really, the excuse given in a statement, and I'll talk about his statement in a minute, is essentially glorified jaywalking, I'll call it. There was not anything that he was doing to threaten people or to harm people when he went over to the Sunshine Grocery. And, you know, when you step back and kind of look at it from that perspective and say, what was Jesse Sarey doing? He was sitting outside of a grocery store, you know, drinking out of empty, discarded cups and cans. It's hard to conceive from the state's perspective of how that encounter, and even the encounter at the Walgreens, ends up in the death of somebody. And really, there's no other way to slice it except for the decisions that were made by Defendant Nelson to disregard his training, to contact Jesse when he frankly could have walked away altogether, to rush in when his training told him to wait for his backup and not approach him, to lay hands on Jesse. Whether Jesse partially stood up or not at the time, what we see in the video and is clear is that Nelson reached down and put hands on him first. That was completely contrary to the training that he received. And the training wasn't just don't do it. The training was, if you do this, what will happen is more violence. There will be a struggle, there will be violence. And I think that again, that's what makes this so much more egregious, is that he knew all of that. And again, you know, we're not talking about an exigent circumstance where Jesse Sarey is harming somebody or we need to intervene in order to protect somebody from him. It was just choices that were made by Nelson to flex his power, I guess is probably the best way to say it. To contact somebody who's vulnerable, as he said himself, down on his luck, just looking for money or looking for something to eat or to drink. So I think that, you know, and again, the court kind of knows all of the facts, but that leading up to it, to even put himself in that circumstance, is egregious. But then the contact itself is also egregious. You know, the court knows that after Jesse responded, and there's no question that he's flailing his arms, as Mr. Woodard said, the Tasmanian devil, he did what training said he would do when somebody in this circumstance. He was resisting. But again, even after he started to resist, the issue is the amount of force that Nelson decided to use. I mean, he had, you know, someone who was significantly smaller than he was, who was not a physical threat to him, and he effectively was able to punch him repeatedly in a very, the court can see on the video and has seen repeatedly, in a violent way, and he really had control over him, and it happened so quickly. But where you really see that he had control is when he grabbed Jesse, and with his arm, he was able to shove him up against the ice box. And he had complete control. Now, you know, again, if we were talking about somebody who didn't have the training that the defendant had, you might understand an overreaction, so to speak, and pulling a gun and shooting somebody. But here, he had all the skills from his defensive training, from all of his years on the police department, to use other tools once he had control of Jesse. Tools other than pulling out his gun against an unarmed person and shooting him in the stomach. And, you know, he could have, at that point, walked away. He could have given him commands. He could have stopped once he had control of him up against the ice box, but he chose to continue to escalate it. I think that, you know, some of what I think that the court should think about in terms of why these actions is, I think you have to look at the history of Defendant Nelson. And I know, again, this court heard, long before I was involved in the case, courts heard a lot of the evidence related to 404B. But that frankly is just a tip of the iceberg. And I think the court knows that. Those were only 10 incidences that were presented by the state, but there was a much longer history. And I think that, I'll focus on just the ones that the court already made factual findings about, because I think it's important. These are not contested facts, or they were contested, but the court has already made findings about them. And I think that, when you look at the history.
Can I just interject? I will say that for the record, what originally was presented to the court, although there were 10 incidents that were argued at the 404B, what the court was originally presented with, and actually as part of that as well, was Officer Pugel's report and a couple other reports from experts who spoke of much broader incidences, and what was focused on in the 404B were the incidents that the court ruled on, but the court has knowledge of other incidents as well that were presented, and those reports were admitted, so.
Okay, thank you for clarifying that. And I think that it is, when you talk about what's the right sentence and how did the prosecutor's office come to a recommendation at the top of the standard range, which I'm sure as the court can appreciate was an extraordinary thing from the prosecutor's office to make that recommendation in this circumstance. But a large part of that, putting aside what happened to Jesse that day, if you can, so to speak, is what the history showed us. And I think there's just a couple of incidences that I want to kind of focus on, because I think that they tell us a lot about Nelson and about the way that he policed. And just to be clear, this is not in any way, from the state's perspective, an indictment of all police officers in any way, shape, or form. I mean, the prosecutor's office has great respect for law enforcement. We all know that they do an incredibly difficult job. And it is the rare occasion, very, very rare occasion, that you have an officer who, in the state's view, abuses the power that they have. But the two incidences I want to talk about are the Winterhawk incident. And the court may recall this. This, started as something that was, some verbal disagreement, I'll call, confrontation. Again, not a situation in which you were chasing a fleeing felon, or you had somebody who was armed, or somebody with a warrant, et cetera. And he followed the individual in the street. And I think that what struck me so much about the Winterhawk incident is the defendant's own words, because this is what tells you what is going on in his mind, in the state's view. You hear him say on the audio, and excuse my language, "You want to fuck them up? I want to fuck them up." Who says that? I want to fuck them up. I mean, think about the attitude that displays from someone that we as a society trust with a gun and say that you have the right to use force in a situation in which you're not dealing with somebody who's threatening you and that you're trying to defend yourself, or threatening anybody else. They're talking back to you, they're disrespecting you. I'm not endorsing that conduct at all. But the attitude that it displayed, and the arrogance, I guess I would say, that it displays to say to another officer, hey, it essentially says, we got the power. You want to go with me and fuck them up? Is really pretty frightening. It's, it shows that it wasn't using violence was not a last resort. It was a preference. He then went on and he, as the court knows, he tased Mr. Winterhawk, and he used a chokehold on him and choked him until he was unconscious. But even again, I will say, focus on his words, because then what we know that he said is that I take the biggest and the baddest and make an example of them. Again, and the defense, I'm sure, will contest some of these things, but these are the words of their client, and these are the words of Defendant Nelson. And again, that's an attitude that he's showing, that he knows that the power that he has as a law enforcement officer and the authority that he has over other people, and when they don't do what he wants them to do, he makes an example of them. Now, in this case, we think that, it's his preference for violence is apparent in this case too. And that's largely because, as I've already covered, he took steps to increase the likelihood of violence as opposed to kind of walking away from it. And he's the one who made those choices. The second incident I want to focus on, because I think it's important for the court to understand, and part of the reason why the state is seeking a sentence at the top of the standard range, is the incident involving the motorcyclist. And I know the court has the video and was able to see the video and considered it as part of the 404B ruling. But, you know, I'll remind the court that this was a motorcyclist who was disrespectful to Officer Nelson when he was in his car, turned around and flipped him off. But what is concerning about what Nelson did in this situation is the fact that he lied about what happened. He said in his report, and the video clearly shows that Officer Nelson drove off through a parking lot and basically pulled in front of the motorcyclist, causing the motorcyclist to hit his car and wreck. Now, the guy fled, as the court knows, and we were never able to find him. But what Nelson did is he claimed, even though his video showed that he had clearly intentionally pulled in front of the guy who was driving fast in order to cause the accident, he claimed that his car had already been stopped in the roadway and that he had no intention to hit the motorcyclist, and the motorcyclist basically ran into him. The reason I highlight that is that that type of dishonesty from a police officer is incredibly dangerous, and it's destabilizing for our community. This court knows how important it is to trust the word of a police officer. I'm sure this court has sat in many, many, many trials where an officer testifies to one thing and a defendant denies it. It can have, the officer's word can have and does have an impact on a person's life in the most severe way possible. And we have to trust that it's placed, and we place a lot of trust in a police officer's word, and we need to, and we always have as a society. As someone who's put on many, many police officers over the years, we endorse what they're saying to jurors. But Nelson really showed in this incident that he was willing to lie about something if it served his purpose. And that is a really frightening thing as a society and as a court, I would suspect, to see that an officer who, even though you have clear evidence of what happened, would lie about what had actually happened. I think that, you know, that carries over here too because of the concern that the state has about the truthfulness of the statement that Nelson made in July of 2019. His dishonesty, in our opinion, was clear from that statement, and as this court knows, the state elected not to use that statement for precisely that reason. And I'm not going to belabor all the points here, but the defense request for a downward departure here, a sentence below the standard range, is entirely based on accepting the truthfulness of Nelson's July 2019 statement. And I would submit to the court that that statement is riddled with lies and justifications, and that is contradicted by the eyewitnesses and by the video evidence in this case. And that the court should reject this idea that he was engaging in self-defense based on a statement that is clearly contradicted by the evidence. Everything and the heart of what Nelson said in his statement, and we have to take his statement in the context of his history, I would say, because Officer Nelson, Defendant Nelson, had been in many situations in which he had to justify his uses of force, as the court noted, many more even than what was presented in Mr. Pugel's report. He knew the game, so to speak. And I don't say that lightly. I mean, it's important that we train our police officers in understanding what the law requires with respect to the uses of force. But there is a certain cynicism associated with the fact that he understood what he needed to say. He had done it many times before. And this statement basically followed that same pattern. The difference here was that there were witnesses who contradicted what he had to say, and there was video that contradicted it. He says that he believes that Mr. Sarey had a knife, his knife, that the blade was open, and that he was going to attempt to stab him. He goes so far as to say he closed his eye, expecting that he would be stabbed in the eye with the knife. That is demonstratively false, as this court knows. It is demonstratively false that the knife was ever in Jesse Sarey's hand open and wielded in any way that could have caused any sort of harm. And we know that from Stephen Woodard, who was right there, and of course we have the video. Now, while admittedly the video doesn't show enough detail to show whether or not he had it, but we know that the knife flew out, and we can see that it was picked up and placed on the hood of the car. So this statement that Nelson made, claiming that he was armed with a knife and imminently prepared to stab him in the face, is just simply false. That is really the basis for the defense request for a downward departure. I'd also note that it's not only Mr. Woodard, but it was also it was Quincy also who indicated that he was there and never saw any sort of action by Mr. Sarey. And the court can see on the video, and I know you've seen it in great detail, as did the jury, and broken down piece by piece, but the state felt that that was important because to really understand what transpired, you had to look at each segment of the video to really analyze whether or not there was true defense of himself in this situation. So we think that the court should find that the statement from July of 2019 is not reliable and that there's no basis for an exceptional sentence down. Finally, I just want to end before we present the other folks, Jesse's friends and family, by talking about the second shot, because I think the second shot, in the state's view, again, speaks volumes and was part of the reason why the state made the recommendation at the top of the standard range. As was just argued, Nelson did not fire these shots in quick succession. He had to reload his gun, had time to scan the scene, and he had to make a decision because he aimed directly at Jesse's head before he fired that second shot. Now, the defense loves to say it takes 3.4 seconds is all he had to make that decision. And we can debate how long that actually is. But I would, as we did in rebuttal argument, point out that, that's really a fallacy because there was no clock that said he had to fire by that period of time. Jesse was on the ground, he was falling away. There was absolutely no reason why he had to fire at that point, as opposed to stepping away and creating distance as he was trained to do, as opposed to firing. But he didn't. I mean, he made a choice, as the court has seen on the video, and I think that this is, as Mr. Woodard said, I mean, this was probably the most shocking part of it, and I suspect the jurors felt the same by how quickly they came to count two, is that even though he was disabled, he was on the ground, he was harmless, Nelson made the decision to reload his gun, point it directly at his head, and fire. That act, when coupled then with what did he do after that? Because again, I think that this speaks to what is going on in his mind. He is trained that after he shoots someone, he's supposed to render aid and help the person. And what you saw in this case and heard from the witnesses is that, and you could see yourself, is that Nelson didn't do anything. Mr. Sarey was not immediately dead. He was certainly bleeding, and as we later learned, he was mortally wounded. But Nelson didn't do anything to try to help him and to render aid. And I think, again, that just speaks volumes about kind of what is happening in his mind with respect to whether or not he values Jesse's life and whether or not he's following the training that he received. For those reasons, the state believes that a sentence at the top of the standard range is appropriate, and certainly the request by the defense for an exceptional sentence down is not justified. I would just say that I think that, one of the articles or one of the letters you read was from Ms. Cushman, who is the sponsor of I-940, and I thought that she put it very well when she said, there are no mitigating factors or circumstances that Your Honor should apply in reducing or lessening his sentence. If anything, there was one factor that weighs toward a longer sentence. Jesse Sarey was vulnerable, and Jeffrey Nelson simply didn't care. We think that that's really shown throughout the course of the entire encounter when he violated his training. It was true at the time of the first shot and at the time of the second shot. And for those reasons, we think that the court should impose a sentence at the top of the standard range. Thank you.
Thank you.
And if I may, I understand that Matthew Sarey is on Zoom, and if he could address the court.
So, Mr. Matthew Sarey, there are hundreds of people that are on this Zoom platform, so I would need you to unmute yourself and let us know that you are here.
Yeah, I'm here.
There you are. All right. And can you hear me okay?
Yeah, I can hear you perfectly.
All right. And we can see you as well.
Mhm.
What would you like me to hear about your brother?
I wrote something about how it impacted, and I'll say something about my brother after.
Okay.
Yeah. Well, I wrote the impact in which Officer Nelson murdered my younger brother Jesse greatly affected my family. Near the death of my brother, just before my mother lost her husband. Soon after that, my mother lost her baby boy to a serviceman, to this community, an officer to the law. Naturally, my mother's heart was broken, shattered even. She shut us out and turned to the bottle. It's very difficult to talk about my mother's passing because of the pain she held on to that led her to that point. My younger brother Terrell took her passing and it consumed him with sadness and depression. A year after my mother's passing, I lost another brother to the domino effect caused by Officer Nelson. All I have left is a son and my youngest brother. Officer Nelson took from this community great individuals who understood good morals and practices and were great members of the community to the state of Washington. They lost 2 men and a woman. To me, I lost my whole world. Officer Nelson deserves the maximum penalty for the murder of Jesse Sarey. That's what I wrote. But my little brother, I want you to know, he's a goofy kid, a good kid. Everybody loved him. He didn't deserve to get killed by Officer Nelson. And it's like, I want to state that if one of us would have did anything in that manner to somebody, like shooting him in the head, we would have got twice as what he's going to get. So it's like, he should have got murder 1. He shouldn't have got that. And my little brother did not deserve that. He was a good kid. He was going through some things. He needed help. And I just want him to get the maximum. And he killed a good kid. That's all I want to say right now. Mm-hmm.
Mr. Sarey, thank you for reaching out and making and thank you to the state for making it possible for the court to hear from you today. I appreciate you being here. Thank you.
Thank you. You're welcome.
Thank you, Your Honor. Next is Colton Sarey, Jesse's younger brother. Yeah, you can go.
I have it written, so I'm gonna read it out.
Do you have a picture there of Jesse you'd like me to see?
Yeah, this right here is a picture of my brother Jesse.
Can I see it?
Yeah, right here. And then
How old do you know when that was taken or how old Jesse was at that time?
this was probably taken, I'd say, 2012, a bit while ago. And this one was taken in 2019. This was me, my mom, and my brother Terrell with the same photo. So that's pretty cool. Here, what I want to say is this. My name is Colton Hart, H-A-R-T. I'm the youngest in the family. I was only 14 when the actions of this happened, and now I'm 20. It's ruined my family's lives and legacy. My brother could have continued his legacy, but now he can't. My mom should have been there to see me graduate, but she couldn't. Like my brother said, the actions of killing my brother led to a domino effect, a ripple effect. It led to a downfall of us as a family not feeling whole, and as a result, struggling to hold on. Back then, I would just play the game to drown out what was already sad, which was the loss of my dad just a month prior to my dad being killed. I didn't want to think about it, and I just wanted this tragic nightmare to end. But my mom was devastated. I was always right by her side. And she was always nice. She always treated everyone like a son or a daughter of hers. To actually lose her son was something that was too difficult for her to comprehend. She couldn't help but think about how things could have been different. but she felt alone and drank the pain away. Both my mom and older brother Terrell were taken from the family too soon due to the pain ripple this caused. And I just been in the middle of it all. I just wanted solace for my family, and now that they're gone, I have to go and experience most of my life without them guiding, cheering me on, and being there when I accomplish goals. If one decision was changed, everything could have been different. If proper training was used, maybe none of this would be happening. I just hope that the lesson is learned at the end of the day. That's all I have to say. Thank you.
Thank you so much, Colton, for being here today, and thank you for sharing your pictures with Jesse. And if you could just leave those up here for, we'll make sure that you get back to
You
them.
want me to put them up?
I'll make sure that you leave with him today, but I think it's important for Jesse to have a physical presence here because this is about him, and yet we've spoken and seen so little of him. So let's put him, you can put him right there just so that we remember that this is really about him and his life. Thank you.
Thank you, Your Honor. Next would be Amelia Dillard, who is Mr. Sarey's foster sister.
Morning, Your Honor.
Good morning.
It's Amelia Dillard. I'm Dillard. Jesse Sarey was my foster brother. Although growing up in the system, we didn't always get to see each other every day. Times that we did spend together were always fond memories. Our community Christmas parties with our foster mom, Elaine, hanging out with Jesse at PSKS, doing our homework together, our fun trips and community outreach that we got to do together. Jesse was a beloved son, grandson, brother, and uncle. When Jeff Nelson made the choice to murder Jesse in cold blood, he robbed this world of a bright light. Waiting for this day, Jesse's family has lost so many, but I know that they are here in spirit to see justice be served, and in that, I take solace. Jesse is missed every day, and today I stand on faith, knowing that even in Jesse's death, there was a purpose. One of my favorite Bible verses is Genesis 50:20 in the New Living Version. You intended to harm me, but God intended it for good, to accomplish what is now being done, the saving of many lives. In this scripture I've read often, I have found it true, or never found it more true than in these circumstances. Today is a day of justice for Jesse, for our family, but it is also a day of justice for Brian Scotum, who Jeff Nelson also murdered in 2011, and Isaiah Obit, who he murdered in 2017. And it is also
Wait. Please no.
a day of justice for the countless lives that, based on Jeff Nelson's track record, he would have ended had he been allowed to continue his reign of terror on the streets. Jeff Nelson has shown no remorse for ending Jesse's life. He has shown no remorse for the criminally brazen way he handled policing, despite both his police and military training, which he chose on multiple occasions to continuously ignore. Jesse will not be forgotten. He will live on in the memories of all that knew him. And I hope and I plead with the court to ensure that as Jesse will not be forgotten, neither will the sentence that is handed down to Jeff Nelson. For the safety of our community, Jeff Nelson's sentence needs to serve both as punishment for his crimes and as a message to other officers that his badge will no longer serve to protect him or others from the punishment of commissions of heinous crimes. He cannot play judge, jury, and executioner. It will not be tolerated any longer. In Jeff Nelson's own words, you take the biggest and the baddest and you make an example of them. I ask you, Your Honor, to please ensure that he is made an example of today, not just for our family and for my brother who he murdered, but also for the community as a whole that needs to be protected from this monster that he is shown over and over to be. Thank you.
Ms. Simons? I'm assuming.
Yes, Ms. Simons, Your Honor. Thank you.
Officer Nelson?
Ms. Simons, I know you want to speak to him. Just look at me.
Oh, I can't turn around.
I just know.
Okay,
It's
okay.
okay. I know that-
Officer Nelson, I have gone over and over in my mind and heart what I would say to you when I had the opportunity. Jesse's family came to America from Cambodia during the Khmer Rouge regime to escape being murdered. His mother, Carrie, was born in a Thailand refugee camp and immigrated to America with her surviving family when she was only 6 years old. Jesse was a first generation born in America. The elders are heartbroken that life in America has been such a difficult journey for her children born here. Jesse is a byproduct of our society's school to prison pipeline, mental health, homelessness, and foster care system. All failed him. He aged out of foster care to be homeless. Jesse never got the opportunity to get off the streets to follow his passion of being a breakdancer with massive monkeys. He was also noted for his head spins, and they played at his celebration of life, June 2023. You, Mr. Nelson, robbed Jesse of his future. I believe his mother, Carrie, died of a broken heart. She saw you arrested and arraigned, but did not live to see this justice served. 1 month prior to Jesse being murdered, she lost her husband and was newly widowed with a 14-year-old son to raise alone. And then she lost her son, Jesse, and never had the opportunity to properly grieve. You, Mr. Nelson, destroyed a family on that fateful day you and Jesse encountered one another. It is a tragedy to be sharing my personal story of my foster son, Jesse Sarey, who I love. When I made my introductions during jury, during the trial, I was not allowed to say he was my foster son. You murdered my foster son, Mr. Nelson, on May 31st, 2019. Jesse came to join his younger brother to live with us when he was 11 years old for 6 months. And even though he had moved out, I had still stayed in his life up to his death. I love Jesse, and this fight for justice has been part of my healing. His younger brother, Terrell, lived with me for 10 years until he aged out of the foster care system. When Jesse lived with me, the boys had many opportunities through community programs such as Shop with a Cop and going to WWE. I bought the boys matching masks and wrestling belts to wear at the event. When we got home, I heard a ruckus from Terrell's bedroom, and both boys were on a broken bed from them practicing some moves, acting innocently. When Jesse moved out, I kept the brothers connected. The brothers had so many opportunities during visits. A memorable one was both boys playing one-on-one with Rashad Lewis and eating pizza with him. They were given autographed shoes. Never know what happened to those. One time, the boys got to go see Usher together, and through my nonprofit Peace for the Streets by Kids from the Streets, another awesome memory was the boys going camping with inner-city outings, approaches between ICO, PSKS, and the Seattle Police Department. Oh my God, all weekend in the woods with cops. Jesse was a funny and sweet young man who loved breakdancing, wrestling, and Naruto. His laugh was a distinct trait of his. Every so often, I watch a video of Jesse dancing as he was a line cook at around 23 years old. You could hear him laughing while prepping food and dancing. Mr. Nelson, you robbed his family and the world of this incredible human. During the trial, I was mostly affected when I saw Jesse's personal effects in the crime scene photos of a broken Power Ranger watch, $2 bills, his medical bracelet, and his Seahawks jersey, the last remnants of his life. When those items were taken out of 5 years of storage, I could feel a sigh of relief from Jesse. When I joined his mother and cousin at the funeral home to bring him clothes, as he arrived with none, the shoes we brought him did not fit him because his feet were so swollen. I was asked by the defense, when was the last time I saw Jesse? It was in the funeral home. Today, we are witnessing that the system is working for Jesse, and it is holding you, Mr. Nelson, accountable for this senseless murder. The system, by design, hoped we would give up waiting for the trial to start. We proved the system wrong. They thought we would go away due to all the continuances. Sentencing was also continued, once again delaying accountability. For 5 years, myself, family members of Jesse, the Cambodian community, and other impacted families and community activists saw justice was served for Jesse. Jesse went from being a hashtag, justice for Jesse, to justice was served for Jesse Sarey.
Okay, excuse me, one moment. Please. My God. We shut down Zoom because of an inappropriate image. We're going to take a minute and, okay. Ms. Simons, I am so sorry, but we're going to take a minute. We're going to get Zoom back up.
I'm sorry.
We're going to take a minute, get Zoom
Yeah.
back up.
Yeah,
And,
that was inappropriate.
And very disturbing. My apologies. We actually spoke of possibly doing a webinar so that we could prevent things like that from happening, but we could not do a webinar and have Matthew Sarey appear. And it was very important to this court that he have the opportunity to speak his voice, his words, rather than writing a letter to the court, because he is Jesse's brother. And unfortunately, someone took advantage of that, so. Ms. Doris, I doubt that you, yeah, and I, unfortunately, I doubt that you, I know I did not have an opportunity to see the name that was with so that we could block them, but I don't, did you, I would assume you didn't either. Okay. My sincerest apologies.
I'd like to add that Colton Hart was not on the protection order, just for note. That's the brother.
And so, as Colton, who spoke today, he is a family member. While we're waiting for that, Colton, would you like to, as a family member of Jesse, would you like to be added to the lifetime protection order? We will add you. Thank you. That's okay. It's unfortunately a situation.
County Superior Court certifying.
Okay, this is Judge Phelps, and I ask that everyone
Nicole
mute
Phelps
themselves.
Gaines, and then there's a link.
You can hire like people, like they'll have like llamas and animals to just show up on your Zoom.
So I'm going to ask you, because you, Ms. Simons, as the elder of the family here, and who, as I understand it, vowed to Jesse's mother to see this through. So I'm placing you in the elder position. Did you see the name this time? Can you remove? Okay. We were planning on taking a recess after your testimony. Would you like to take a recess so we can get this situated now? Or
Yeah.
And then come back?
And then I could just continue from there. I'm not going to start over.
You don't have to start over.
Okay.
I will, because I understand this is emotional and.
Yeah, that's fine.
But I also don't want, I want to give you the choice. I don't want you to have to stand here while we get this figured out. But I also want to give you an option of waiting and getting it figured out, or taking the recess now and coming.
Do I need to do it on Zoom?
The reason why we
Oh,
have to
public
have.
hearing. Yeah, yeah,
Yes,
yeah.
yes.
We don't want to redact anything.
We don't want to issue where I've closed the
Yeah.
court.
Okay, yeah,
But what I
I'm
will
fine.
say is that I also have an obligation to protect the court from absurdities. So if that continues to be a problem, then I'm going to make the necessary findings that I need to find that I'm not closing the court, because people can most certainly come down here. We have 2 courtrooms available that they can attend, and I will not start the Zoom again. So we're going to take if it's okay with you, we're going to go ahead and take our morning recess. We're going to try and work with IT to get this figured out and see if we can keep this out. If not, I'll make the appropriate findings that I need to find not to use them. As we do so, I want to remind everyone, please remain respectful of one another. And as we exit to the break, it's going to probably be a little more than 15 minutes, because we've got to work with some IT issues here as well. So we're going to be in recess for a few minutes. And as you exit, I would ask that you be mindful not to hang around in the lobby area. Please utilize the fresh air that is outside. If you need to get fresh air, feel free to exit the court and do that. Let's find.
Spooling?
I don't know. I mean, it's showing. It's showing nuts.
No, it's showing the other courtroom.
back my mom's neck. Put her daughter in the
Oh, those are the daughters.
arbors.
I left the house at like 6:30 to make sure I got here.
Yeah. I ate breakfast. I had a lot of coffee.
I was just wondering whether he was responsible for much of that. In terms of thinking about it.
Thinking about it, yeah. I put my own, started spitballing usually.
We get in 5 minutes, we're gonna go back. I don't wanna leave them in cuffs for too long.
I'm gonna ask.
I don't know if they have, how many people in the division?
Shit. We were down. Yeah. Pretty loaded. There's 1, 2, 3, 4, 5, 6, 7, 8, 9. We were down like 4 bodies. That sucked. But I'm training. I've got 3 people. I guess maybe we have 10 now. I'm training 3 guys that all join the game at the same time. Any
All right, thank you everyone for your patience. I think we are back on a separate Zoom link, but I want to, please be seated, sorry everyone. I do want to point out that the court is providing the Zoom access as a courtesy. It is not mandatory because we have seating available here in this courtroom. We also have an overflow courtroom. And so should the issue happen again where someone displays inappropriate material, specifically what happened in this case is there was pornographic material displayed, the court will discontinue the Zoom link and we will continue only with in-person. I will let the public know that you are welcome to come to the King County Courthouse, MRJC. We have 2 courtrooms available for you to observe the proceedings this morning. With that, before I get to Ms. Simons, Ms. Eakes, is there anything else that you would like to put on the record before we move forward?
No, thank you very much, Your Honor.
Ms. Murray, is there anything that you would like to put on the record before we move forward?
Yes, I just want to make a better record of what we saw. So when Ms. Simons was speaking and mentioned the hashtag for Jesse Sarey, the screen went black and a hashtag appeared, and then that's when we saw lots of pornography come on and lots of noise when we tried to bring it back. So, and it was pretty explicit pornography, so that, I just wanted to make sure that how it came about.
Thank you. I was looking at Ms. Simons, so I didn't see the initial. And yes, I think that is, I appreciate you doing that because I did not see the initial beginning. And I will say we tried to close out that link and come back into that link and it remained. So we've now set up a second access and we've given it to close friends and family only for both defense and prosecution. And the media has been instructed that they cannot post that link. Again, this is not a closure of the courts because the court is here. Zoom is being provided as a courtesy. We do have proceedings available for people to be here in person in 2 separate courtrooms. All right, Ms. Simons, and I will tell everyone, patience, please. Obviously, we are not going to end at noon today as we had anticipated, so we'll be here for a while today. So please, just graciousness for your patience. Ms. Simmons. Ms. Simons, I'm sorry, Ms. Simons, after all this time.
Thank you.
Ms. Simons.
Waiting for this murder trial has taken a tremendous personal toll on me emotionally. I fought this fight through traumatic loss as my father died in October of 2020. Jesse's mother, Carrie, died in June of 2021, and I had to take her off life support with 2 of her nephews and her best friend. In August of 2022, his younger brother, Terrell Sarey, whom I raised, died. Jesse's biological father had died in Cambodia years earlier. Only Jesse's younger and older half-brothers are alive. Jesse's bloodline died with him. I believe they were all in the courtroom with us throughout the trial. I believe they are here with us now. I could feel Carrie holding my hand and thankful that whoever sat next to me did just that. For over 2,064 days, I had stayed the course, but this fight came at a huge cost to me and my family. I personally had to take unpaid leave of absence from work to ensure I could be in the courtroom throughout the entirety of the trial, while you, Mr. Nelson, was on paid administrative house arrest. I'm pleased those years do not count in your sentencing. I have not yet taken time off for bereavement, and my grief is immense over so much loss. As I shift from fight mode to self-care, the deluge of emotions become a transformative journey of growth and renewal. Mr. Nelson, you murdered Jesse, who was not only my foster son, but a human being who did not deserve to be murdered in this way. No human being should die in this manner. That photo of you with a grin on your face not long after you murdered Jesse speaks volumes. It haunts my mind, and I will never unsee it. Forget it. It made me feel that you did not value Jesse as a human being. To this day, I don't know what his last words were. Perhaps you will share that with our family. With his Kilmer family and supporters by my side, we got you a killer caught, arrested, indicted, and convicted with second-degree murder and first-degree assault. Mr. Nelson, you were the last person to be next to Jesse as he died, and you failed to render aid, where other heroic police officers did. We were not notified of his death until June 1st, 2019. He died alone in a hospital and was identified only as an unknown male. It was not until he was at the morgue did we get notified. When I got that fateful call on the 1st of June from my son Terrell, Jesse's younger brother, asking if I had photos of Jesse, I knew he had to be the person who was misidentified in a police shooting in Auburn. I was heartbroken that something happened to other families happened to us, and no family deserves this, Mr. Nelson. We gathered at his aunt and uncle's home in disbelief, not knowing the journey we were about to embark on. I was asked by Jesse's younger brother, Terrell, to be Jesse's stalwart advocate to ensure his murder did not fade away and kept its center of focus. Your Honor, I was appalled by the dozens of Auburn police officers that showed up in support of Mr. Nelson when I testified at the arraignment, asking for bail and throughout this trial. It is incomprehensible that a person charged with second-degree murder and first-degree assault at that time had no bail set. That he was able to make bail and be paid administrative house arrest all these years was another disrespect to Jesse. I was disgusted by the lack of remorse by the defendant, Mr. Nelson, throughout this trial. I would rather be judged by 12 than carried by 8 is one of the redacted tattoos Mr. Nelson has inked on his body, which seems fitting as today is his judgment day. I truly believe the only remorse he had was that he got caught. It was like looking into the eyes of a soulless individual. Your Honor, Mr. Nelson committed a horrific act of violence against Jesse and the community. He is a public servant and should be held at a higher standard. I am hoping for accountability and closure for myself and the Sarey family. Prison time for murder and assault underscores that no one is above the law. I am asking for consecutive sentencing for Mr. Nelson at the highest sentencing structure. However, I understand that it would probably be concurrent, and I hope that it is also at its highest level. I also recommend mental health counseling for Mr. Nelson to understand the harm he has inflicted on our family and community. I want to applaud the decorum demonstrated by both Mr. Nelson's and Jesse's families and supporters during the court proceeding. This is a resolution for all of us. Both families have been impacted by Mr. Nelson's action. We all have to go forward in life dealing with the decision he made. To Mr. Nelson's families and supporters, I hope you have the resources to help you navigate through this. We have all been impacted. The citizens of Auburn lost faith in their police department when Mr. Nelson violated his civic duty as a police officer by using unwarranted deadly force. To this day, we have not had a formal apology from Auburn Mayor Nancy Buckus. What will the city of Auburn do to acknowledge Jesse was murdered on their watch? They owe us, the community, Jesse's family, and friends an apology and remorse. I know there are police who go into this profession with good intent, and I hope this gives you permission to call out when you see bad actors at your place of work. To active police officers, I want to believe any reasonable police officer in a similar situation will think twice before using deadly force. People are paying attention and now have hope that their loved ones who encounter police will make it home safely. A former police officer who knew Jesse wrote to me on my persistence with this case. Elaine, I've watched and read the news. What stands out to me is your dedication, composure, and eloquent ways. 20 years ago would have been a different story. In closing, the conviction and sentencing is a reminder of the importance of exposing and eradicating the wrongful practices of civil crimes administered by law enforcement, so often targeting people of color throughout our country. We must continue not to just fight for Jesse, but for all impacted families of police-sanctioned violence. This conviction sets precedent in Washington State and gives hope. It has been a long journey since the fateful day Jesse was murdered on May 31st, 2019. However, I never gave up pursuing that justice be served for not only Jesse, but for all the victims of this rogue police officer. Mr. Nelson is also responsible for the death of Brian Scammon and Isaiah Obit, as well as many dozens of misconduct that were redacted in earlier motions. I hope that this conviction brings peace to their families as well. I want to acknowledge the jurors who did their civic duty on a difficult case. I applaud all of you. I hope that this will inspire other impacted families not to give up hope and to stay in the fight for their loved ones. That's what I've been fighting for this whole time. It's not just about Jesse, but his legacy will be to help find justice for all people who find themselves in the same space. Jesse's death made history. Jesse's life is saving lives. He is significant. Thank you.
Thank you, Ms. Simon.
Thank you, Your Honor. The state has nothing further to say at this point.
Thank you. Ms. Murray.
I want to start the defense presentation by presenting our speakers. I think it's important that the court hear from them first,
Okay.
and then I'll give the court my remarks in the end.
Okay.
So our first speaker is Officer Nelson's wife, Natalie Mounts.
Good morning, Your Honor.
Good morning. Thank you for being here.
My name is Natalie Mounts. Last name is spelled Mounts. Jeff and I have been together for 11 years, so I think it's safe to say that I know him better than anyone. I don't have words for how hard May 31st, 2019 was for Jeff. We had just moved in together, and I'll never forget him coming home that day. He's very good at keeping calm when things are difficult, which is why the day sticks out so much. I could tell he was in distress and that he was replaying the incident over and over in his mind. I was relieved he was okay, but I could tell he was in turmoil. Jeff knew that his life was in danger the moment that Sarey grabbed his gun. The literal fight for his life that followed was one of the worst he's ever been in. And the most important thing was to survive. Jeff wishes that things had turned out differently. He wishes that he had known Sarey had dropped the knife, but he didn't. When he fired those shots, it's because he was sure his life was in danger. I don't think he regrets anything more than not seeing that the knife had dropped to the ground. Jeff would never shoot someone he knew to be unarmed. And Jeff and I are very sorry for the loss suffered by the Sarey family. When he came home, I learned quickly that Jeff was physically hurt badly. Not because he told me he was, but because he winced in pain when I tried to hug him. I know Jeff to have a pain tolerance, so this really surprised me. For weeks, I was unable to fully hug him because of the pain in his ribs. To this day, I can see the uneven nature of the injured side of his chest, which sticks up much higher than the other side. The state wants you to believe that Jeff is a monster, and I need you to know that nothing could be further from the truth. They've never even met him. They've never had a conversation with him. They've never gotten to know him in any way beyond watching videos and reading police reports. Everything they've said about him today is based on tiny snippets of his work. So I'd like to talk about his work. Jeff and I met because we both worked at Auburn PD. There's a saying out there that goes, "Find the helpers." Working anywhere near Jeff, you didn't have to look far. He was always willing to lend a hand on calls or help people with tasks. He even took time to help retrain an officer who was on the verge of failing out of training. From the letters submitted to this court by his friends, family, and coworkers, you'll know that I'm not the only one who feels this way. There are so many stories of Jeff lending a hand, lifting spirits and helping others. Half our department is either in the audience or watching on Zoom, not out of obligation, but because of who he is. Jeff has always been a leader that we count on while working patrol. When I was a few months out of training, someone tried to kill 2 Auburn officers. When I arrived on scene, we had no leader. Our sergeant hadn't responded. Jeff was the first person to give guidance on what us brand new officers should do. He was calm and reassuring with the suspect still outstanding. I will never forget how safe I personally felt in such an unsafe situation. When the suspect was located, Jeff was primary into taking him into custody. The person was hiding, still with their firearm, yet Jeff led our crew in giving clear commands in order to arrest him safely. The state wants you to believe that Jeff has a desire to hurt people, that he uses his authority to get away with it. If this was true, that call would not have ended the way that it did. Jeff is the one who rallied us together, put together a plan, and carried it out peacefully. Jeff's leadership extends to teaching new officers how to treat people and the proper way to interact with them. Once his crew had a very serious child sex assault suspect in custody. The more they learned during the investigation, the more upset officers became toward the suspect. Jeff pulled everyone together to stress the importance of having restraint and treating the suspect with respect, no matter their own feelings. The state wants you to believe that Jeff is callous, that the things he said at work show that he doesn't care about people. The truth is the exact opposite. Police work is extremely hard. We deal with people's worst day every single day. Jeff has always looked out for his team, often making jokes to cheer us up. His humor is what made me...
It's okay. If you need to take a moment, it's okay.
His humor is what made me fall in love with Jeff in the first place. I've watched him cheering coworkers up since my first day at Auburn, and he never stopped, even when his world came crashing down because of this case. The state says that he does things off camera to hide it, yet they've shown you videos to prove their point. When you watch those videos, the worst thing that you can accuse him of, if anything, is poor timing. But I assure you, he has never wanted to hurt anyone. He only wants to help us get through those tough days. Jeff's whole life has been dedicated to serving others. He joined the military with a dream of becoming a police officer afterward. He told me that from the time he was a kid, it was the only thing he dreamed of being. He has a heart of service and a need to take care of people. From the letters submitted to this court about him, you'll hear how for years he has chosen a family or someone in need to bless at Christmas time. One year he responded to a call and learned that the family didn't even have a Christmas tree, so he went out on his own and bought them one. Other years he fulfilled wishes of each kid in a family to make sure that they had presents under their tree on Christmas morning. Jeff didn't want notoriety. He didn't even want me to tell that story. He was so quiet about it that I didn't even know about it for the first few years of our relationship. He He wasn't doing it to receive praise. He was doing it because he didn't want kids to grow up with nothing. Jeff has such a gift for making kids happy. When you first met my nephew, he was laying on the living room floor, playing trucks with them, while everyone else sat in the kitchen and ate dinner. A friend of mine who's uncomfortable around men expressed to me when she first met him that he's the first man in years she had felt comfortable allowing her daughter to be around. All our friends with kids bring them along when it's time to go to Uncle Jeff's house because they all love being around him. Jeff also has a love for animals, which is what led him into canine. The state wants you to believe that he got a canine as a tool to hurt people, that he and the dog have many inappropriate uses of force. Through his career, Jeff has 0 excessive uses of force. He worked his canine with pride to catch the worst of the worst, many of which would not have been found without his dog. He was willing to go to the worst calls and utilize his canine when necessary to keep citizens and his coworkers safe. Jeff worked very hard to become a reliable canine team and developed a deep love for his dog. But it's not just dogs, and it has nothing to do with the police aspect of his canine team. Since Jeff and I have lived together, I've watched him care for every living creature at our home. He's been feeding the hummingbirds so lovingly that he brings the feeders in on cold nights to prevent them from freezing over. Since our cold weather started this year, he asks me consistently on our phone calls if I'm doing the same because he can't be home to do it. He developed a close friendship with cats that were supposed to be outdoor working cats. Before I knew it, our barn cats were cuddled in his lap while he watched TV. When we lost them, he was deeply hurt and buried them in our yard, along with a plaque he made by hand. Jeff was on house arrest for most of the time we've lived in our current home. Despite that, he made an effort to get to know our neighbors. Just last month, he asked me to be sure I'd send them Christmas gifts, as he's been doing every year since we've been there. All that said, the most important thing to Jeff is his family. Above all, his daughter. Jeff has done everything in his power to give his daughter everything he never had. To protect her privacy, I haven't said and won't say much about her, except that she needs her father, just as he needs her. Jeff will do anything for the people he loves. During our daily phone calls, he makes sure I'm checking on our family members for him. My sister recently spent time in the ICU, and I have parents undergoing life-saving medical procedures. The first thing he asks on every call is how they're doing. I need to be home for Jeff, more now than ever, but he is continually urging me to go visit those family members so that we, through me, can continue to care for him. One final story that comes to mind is that my grandpa for years had wanted a hot tub. One Father's Day it came up again. Jeff quietly disappeared and returned about an hour later. He had driven to a nearby store to buy Grandpa an inflatable back porch tub, the best thing he could find until they got a real one. When Jeff sees an opportunity to make someone happy, he takes it with no questions asked. It doesn't matter the time or investment that it requires from him. Please understand that the picture the state is painting is a lie, crafted to take down an honorable man. I will never understand why. I can never understand how they think this is okay when they know the truth and when they've hidden that truth. Jeff's family needs him home. Jeff needs to be home. He is my hero and my champion, and I need him home. Please consider who he truly is before laying out his sentence. Thank you.
Thank you for being here today. Thank you for speaking. Thank you for sharing a part of Defendant Nelson that I may not have otherwise known. Ms. Murray.
Your Honor, the next speaker is Kevin Wetland.
Was it Wetland?
Your Honor, Kevin Wetland, W-E-T-T-E-L-A-N-D.
Did I get a written statement from you?
No, ma'am.
Okay.
Jeff is my son-in-law, but we've been together so much in the last 5 years, I consider him a brother. I personally been around him since about 2015, and nothing I can say ever comes mean or nasty out of his mouth. Any hardships that's ever been around us, working around the house, working out, he's always been there. He's been a champion. He's he's been a rock through this whole thing. He's meant so much to me in learning how he takes care of his family. He takes care of the people around him. Natalie spoke of a sign at the time about Christmas gifts, and I didn't know, but he was under house arrest. He had his crew go out and do the exact same thing while he was under house arrest, and he did it again. Jeff loves his daughter, loves his wife. His wife is just like my wife. We would have conversations about each of us making our wives crazy and how we could fix it. And so we became that bond of, uh-oh, what do we do now? The last 4 years, I've learned how the love not only goes through family, it goes through the people he worked with and the people that he served in military time with. He honored them. He honors them all the time. He puts their honor on his arms. When he was in the military, he was a young kid and walked into a tattoo shop and basically said, the tattoo artist said, I have a 2-for-1 special. He said, okay, put the same tattoo on both arms. You know, he just had a funny way of going around things. He put his daughter, who passed away, on his arm. He put the wings on his back. He puts his canine that he served with on his leg. He honors the people that he's been with, the people that he serves. He has no mean bone in his body when it comes to being around people. I've seen him in action around people when we go to the store. He laughs with them, he jokes with them, he talks with them. There's never any, I'm better than you. Matter of fact, most of the time, people don't even know he's in law enforcement. When he was younger, he spent most of his time growing up with his granny, who was a Native American in West Virginia. He learned how to hunt, he learned how to be in the woods, he learned respect from her. That was one of his fond memories of a young kid. The most thing that got to me about Jeff is one of the stories he told me. He was on patrol. He stopped at 7-Eleven to grab a drink. While he was there, he saw somebody sitting on the curb. He went inside, got a drink, sat down next to the guy on the curb, asked him what his name was, what he was doing. At one point, he went in and asked the guy if he wanted a drink. Jeff went in and bought a drink for him. Next moment, he found out that he was a vet, was homeless. Jeff purchased a bus ticket for him so that he could get back. That's the type of person Jeff was. Jeff was looking after everybody. Natalie talked a little bit about the injuries with Jeff. Jeff and I have worked out constantly for the last 5 years, 4.5 years. And during that time period, I noticed the issues that he had with his chest and his hand. He couldn't do his sit-ups. He couldn't do stretching. He always had a pain in his chest. The point that after 2 years, he still had the pain. And I got on him to get hold of L&I to go back in and get looked at by a doctor. The doctor finally did an MRI and found out that he had torn cartilage in his ribs. They ended up giving him an injection to help him with the pain that he was suffering for 2.5 years. And he was just starting to get better as the trial ended. So that tells you what kind of pain that he suffered during that time. He also suffered pain in his hand when he broke his knuckle. And the hospital didn't x-ray it. They didn't do anything to look at it. His knuckle was pushed back in his hand, and when he went in to get it looked at, they basically said, yeah, you had a spiral fracture. So the state wants to say he wasn't injured. He didn't hurt himself. It wasn't a fight for life. But the injuries where he couldn't breathe. He told me that he was out of gas. He was gassed. Nothing he could do. And the state wants to say that he was fine. He just didn't render aid. No, he couldn't breathe because he was injured. I've been in law enforcement for 32.5 years. I'm a supervisory special agent in the federal government. I've always believed that justice is equal, and under the law, everybody has the same opportunity. Unfortunately, during this trial, the state has proven they are much worse than the defense has been. That is the problem with this system right now, is Jeff did not get a fair trial on this.
Ms. Murray?
Your Honor, the next speaker is Sam Betts.
Vets or Bets?
Betts, B-E-T-Z.
Good morning.
Good morning.
My name is Sam Betts, B-E-T-Z. I currently work as the Assistant Chief of Police for Auburn PD, and I've worked for Auburn PD for nearly 19 years. I've known Jeff Nelson for 16 years. Jeff is someone who has earned my trust and respect over the years through his behavior, and he is someone who has lived a life of service to both his country and to his community. He has earned my trust and respect through his focus on actions that benefit the common good of our community, our organization, and our smaller teams. The service mindset that Jeff has embodied has been evidenced throughout all of his adult life. He served the people of this great nation overseas on multiple deployments, and he quickly transitioned into service for his local community after his military service concluded. As a police officer, he served the people in the Auburn community through his life-saving actions on multiple occasions, like in 2017, when he helped save the life of a subject who was overdosing on drugs. He has received appropriate and well-deserved department recognition for his courage in the face of great danger to himself and the community. Jeff has demonstrated his heart of service to his fellow employees through phone calls and visits of support during difficult circumstances involving both professional and personal circumstances when others were facing adversity. He has served through face-to-face conversations, like he did with me when I was faced with personal tragedy involving one of my children. But I still needed to come back to work and do my job effectively. He would find me when I attempted to seclude myself, and he would talk to me about the tragedy because he was able to empathize with me due to his own previous similar circumstances. Jeff has been vilified by many people, but the actions that I have witnessed have shown that he has a heart of service over self. My observations of Jeff Nelson's professional and personal behavior lead me to give him unwavering support. In my current role with the police department, one of my responsibilities is recommending discipline for department employees. I have recommended the highest level of discipline, termination, for multiple employees, and I do not hesitate to recommend appropriate discipline after considering the facts and circumstances of each situation. My consistent professional record demonstrates that I have acted with integrity and honor while having very limited patience for people who act without integrity and honor. I attempt to evaluate each situation with an objective and reasonable lens while considering the responsibility of each party involved in the situation, from the employees to the community members and any other involved parties. I am not swayed by false or inaccurate narratives which are based on self-serving agendas. I can say without hesitation that Jeff Nelson is not a person who I believe abused his authority as a police employee. Thank you for your time.
Our last speaker is Christian Adams.
Good morning.
Good morning.
I am Christian Adams, ADAMS, and I'm currently a commander with the Auburn Police Department, and I have been with the police department for 19 years. Excuse me. I'm currently assigned to the Administrative Service Division. I was hired in 2005, and Jeff was hired in 2008. After he finished the academy, he was assigned to the Patrol Division, where he and I got to work together. My wife and family always felt safe when Officer Nelson and I worked together. We all knew he was a tactically safe officer and would be there to assist me anytime I needed. My wife would tell me, "I'm glad Jeff is working with you tonight," when I would walk out the door and risk my life going to work to protect and serve the community. Despite what has been said about Jeff in the media, that is not the person who he is. As a Black man who happens to be a police officer, I asked to be here and speak about my experiences with Jeff Nelson. I'm a Black man in and out of uniform, and I trust Jeff and believe him to be a fair man. I've always saw Jeff treat people, regardless of their race or gender, equally. I've always been treated fairly by Officer Nelson. When there were multiple protests in the region post George Floyd, Jeff supported the fact that I went out and took a knee with the protesters. It was an unpopular opinion in some law enforcement circles, but when Jeff and I spoke about it, he told me thank you, smiled, and said he was glad no one got hurt. He knew at this protest we were at, where I took a knee, there was a curfew and chemical agents would be used to disperse the crowd. But his happiness came from seeing that no force was used, there were no injuries, no arrests, no issues. I have worked with Jeff for years and responded to hundreds of calls for service with him. I have never seen him treat anyone differently based off their race or gender. He has treated all people the same way, and that's fairly. This is a man who served our country and our community. Never once did he make me feel like he treated me or others differently because of race or gender. Despite what skewed things are being said about him, I know these things are not true. I know the true Officer Jeff Nelson, and I support him and I trust him. Thank you.
Your Honor, when Officer Nelson was dispatched and responded to the call from Mr. Sarey on May 31st, 2019, he thought it would be a routine encounter. He didn't go out looking for Mr. Sarey. He was dispatched there, and he responded. He had no idea that what would end up being would be a tragedy. He thought this was going to be a routine arrest and that he could safely take Mr. Sarey into custody. And he was wrong. The state has tried to present the facts of this case and the evidence that has been presented, not just during trial, but during all of the pretrial hearings that we've had, as one-sided, that this was just about Officer Nelson, and that's not accurate and it's unfair. When Officer Nelson attempted to arrest Mr. Sarey, he resisted, and then he fought Officer Nelson. He grabbed for his firearm and he took his knife. Officer Nelson truly believed that he was in the fight for his life.
I need to write some notes on my notes.
No worries.
But I want to make sure I'm giving you my full attention. Give me one moment. Okay.
He truly believed that he was in a fight for his life. And then I know that the court has read all the pleadings that we filed, the initial defense sentencing recommendation, and then the reply that we filed this week. And I trust that the court has read all of that thoroughly. It is very clear that just as throughout this entire case, what occurred at the Sunshine Grocery is very disputed between the parties, that this is very divisive. But there is clear evidence that Officer Nelson acted to defend himself and that he never wanted this outcome. He never wanted Mr. Sarey to die, and he will always be sorry that he did. This was a tragedy. We told the jury that. We've told the court that throughout the pendency of this case. For Mr. Sarey and the immeasurable loss to his family, but also to Officer Nelson and all the people who love and care for him. At the time he fired those shots, Officer Nelson believed Mr. Sarey had his knife. We all know now that he was wrong, but he did not know that at the time. And when you look at the video of what occurred, it makes sense that he wouldn't have known that. We talked about that during pretrial hearings. And he wishes every day that he had seen that knife fall to the ground. Because then Mr. Sarey would be alive. Because he never would have shot a man he knew to be unarmed. Now, the state argues that the defense's request for an exceptional sentence below the standard range is based entirely on Officer Nelson's statement, and that couldn't be further from the truth. And I know the court knows that because the court read the pleadings that we filed. The state's argument that there's no basis for the defense to request an exceptional sentence blatantly ignores the statements that Mr. Woodard gave immediately after the shooting, where he clearly said that this was a mutual fight, that Mr. Sarey fought Officer Nelson, and that he kept fighting and fighting, that Officer Nelson's attempts to subdue him and to stop the punches had no effect on him, that he kept fighting, fighting, fighting. They ignore the DNA evidence, that Mr. Sarey's DNA was on the knife, They ignore the toxicology evidence that showed the high levels of methamphetamine in Mr. Sarey's system, and they ignore Officer Nelson's actions after the fact and demeanor immediately after the fact. Now, they point to the fact that he didn't give aid to Mr. Sarey. That's awful, but Officer Nelson was also injured. And that evidence was made clear during trial. The court saw evidence of that. The court heard from Ms. Mounts today about that. He'd just been through a traumatic incident. And when you think about the statements that Mr. Woodard and Mr. Williams said about how Officer Nelson looked after the incident, that makes sense. Mr. Woodard described him as looking devastated. Mr. Williams said he had a blank stare on his face. And Officer Jendrick, who was the first officer that responded, said he was so alarmed by how Officer Nelson sounded, that's why he came flying into the parking lot like he did. He had never heard him sound like that before. His demeanor after the shooting shows that this was something he wanted thoroughly investigated, and that is not the actions of someone who's trying to be a rogue officer or trying to flex his power or trying to hide something that he's done. He turned on his Coban before he went to the Sunshine Grocery so that the entire communication would be audio recorded. That's why we have all the things that Officer Nelson said to Mr. Sarey. You can hear how he talks to him when he walks up to Mr. Sarey at the Sunshine Grocery. You can hear him saying, listen, listen, even after Mr. Sarey starts fighting him. After the shooting, he asked officers to preserve evidence. He asked them to mark off perimeters. He asked Mr. Woodard to stay, the only witness that actually watched that. Why would he do that if he was trying to hide what had happened? He did all of that because he wanted this case and this incident thoroughly investigated. Now, throughout this case, and certainly in its pleadings for sentencing, the state has sought to assassinate Officer Nelson's character. This has been one of the most contentious cases that I have ever been involved in. They want to paint him as some rogue cop who abuses his power, that violence is his preference. Now, they point to other incidents that they brought up and litigated in their attempt to admit them under ER 404B and during our pretrial hearings. Ms. Eakes today said that it was just the tip of the iceberg with his history. Now, as the court knows, all of these incidents were heavily disputed by the defense. The defense has always disputed the characterization that the state has made regarding these offenses. Now, they presented 10 offenses, and it's true, Your Honor, they had a report from Mr. Pugel. His report included 17 offenses, 10 of which the state chose to bring. But when you consider how long he was an employee with the Auburn Police Department, 11 years, and the number of contacts he would have, that's nothing. If he was really the monster and the rogue officer who abuses his power that the state says he would be, there would be so much more documentation showing that, and there's not. All of the incidents that Officer Nelson had for uses of force were investigated by the Auburn Police Department. He has never been found to have used excessive force by the Auburn Police Department. They have to investigate complaints. They have to investigate uses of force. The fact that there is not more documentation shows that he's not who the state has tried to portray him to be. That it can't be true, and it's not based in fact. Now, all of the people standing behind Officer Nelson or sitting behind Officer Nelson know that to be the truth, and that is why they're here. The court has seen throughout this trial, and certainly in the post-trial motions that we had, and certainly today, that Officer Nelson has an enormous showing of support. People came to support him during the trial. People were here and filled the courtroom during our post-trial motions, and they have filled the courtroom today. He has the support of friends, family, fellow officers, the Auburn Police Department, and the city of Auburn mayor is here to support him today. You do not have that kind of support, Your Honor, if you are a rogue officer who abuses your power. You just don't. Your support has been unwavering in this case, and that speaks volumes. Now, police officers go into this job because they feel an obligation and a duty to serve, a duty to protect and serve their communities. They're not going to stand by somebody who abuses their power, who abuses the public trust, or who hurts people. If you think back to all of the other cases that we have all seen, the horrible cases that we've seen over in recent years with officers who have abused their power, you don't see the kind of support that Officer Nelson has here. You don't see fellow officers standing behind them. They're not going to believe, and they're not going to support somebody that does that. Now, that's why the defense wanted the court to hear from the speakers first and to look at the letters that we provided as part of our sentencing packet to try to show you who Officer Nelson is. The story that Mr. Wetland told about the unhoused veteran, who Officer Nelson paid for a bus ticket for him to go home for Christmas because he couldn't afford it. You know, the story in one of the letters about the unhoused man named Kenny, where Officer Nelson taught a younger officer compassion. The story about Officer Nelson talking the veteran off the ledge who was trying to kill himself, and that he was able to communicate with him. That is not the picture the state has portrayed for you. That he goes around to unhoused people and vulnerable people and flexes his power when he's disrespected. These two things don't fit. The state doesn't know who Officer Nelson is, but the people who support him do. They know who the person he is. And throughout this case, the state has simply ignored or tried to hide the evidence when it didn't fit their narrative. This is not how our system is supposed to work. We are supposed to be better than that. The state is asking for the high end of the standard range. They're asking the court to make an example out of Jeff Nelson, to send a message. I will tell the court, and the court knows this, you know, I've been representing clients for over 20 years in King County criminal courts. I have never seen the King County Prosecutor's Office go after someone the way they went after Jeff Nelson. Police officers need to know that they will be treated fairly in this system. And that's not what happened here. The state has tried to push this false narrative on this court to present Officer Nelson as the poster child for bad policing in America, when that's just not the case, and that's not okay. The circumstances of this case were tragic. Officer Nelson never wanted to be here, and that is not because of this court case that resulted. He never wanted to be here because he never wanted Mr. Sarey to die. Now, he's not perfect. None of us are. Has he had some bad days and maybe not been his best self? Of course, all of us have that, particularly people who are very stressful jobs. But he's not the person the state has tried to paint him as. So considering the circumstances of this case, all of the circumstances, Your Honor, that this was a fight, that this was a fast, violent, dynamic encounter, that this wasn't just Officer Nelson's choices, but unfortunately Mr. Sarey's as well, that ended in tragedy. The defense is asking for a total sentence of 78 months confinement. If the court does not grant the defense motion to vacate count 2, we would ask for a sentence of 78 months on each count to run concurrently. Regarding legal financial obligations, Your Honor.
Okay. I was about to ask you a question about that, but I understand what you're saying, because I was like, wait a minute. But regardless, you're asking for a mitigation down from the standard range. So if I don't vacate, it's obviously, because
Right.
Gotcha.
So it would be 78 months total for both counts, which is a downward departure
DDA.
for both counts.
Okay.
And then the concurrent, because it's same criminal conduct. That there's no DNA fee per statute now, and so that should not be imposed. We obviously don't have an objection to the $500 victim penalty assessment. With respect to restitution, if restitution is sought and a hearing is set, we will appear on Officer Nelson's behalf, and he will waive his presence at that hearing. So we would just ask the state contact us for that. And we, of course, have no objections to the request for no contact orders as part of sentencing with Elaine Simons, Colton Hart, Matthew Sarey, and Mr. Woodard. Thank you, Your Honor.
All right. I'm going to ask for your indulgence just a moment. I need to integrate some handwritten notes that I had taken into my very prepared remarks. Give me one moment.
Your Honor, I may interrupt. I believe you need to at least offer Mr. Nelson.
Oh, my goodness, yes, thank you.
Thank
Oh,
you.
so sorry, thank you. Thank you. Mr. Nelson, you most certainly don't have to speak. You have the right to remain silent. But having been convicted, you also, under the law, have a right of allocution, meaning that if there's something that you wish for this court to consider from your own words, if you've prepared a statement or otherwise, I would like to hear from you now, and I will give you the opportunity to do so.
Your Honor, Ms. Murray has spoken on my behalf. No, thank you.
Okay, thank you. Thank you for catching that. Sorry. One thing I want to ask defense, I know that these came in late yesterday. Were you able to give Mr. Nelson, Defendant Nelson, a copy of the victim impact statements that were filed?
Not yet, Your Honor.
I went.
We do have copies, though.
Okay, well, I want to make sure he has a copy of these. Specifically, I would hope that you will read them. There is a statement in there from Stephen Woodard that I think he very much wanted you to understand the impacts of what happened based on his observations. I do hope that at some point in time, you will take the time to read through those to understand the ramifications here, and that this is not as simple as your life changing, your family's life changing, or the Sarey's family life changing, but everyone that has had any intersection with any part of this case, be they community persons or family members or supporters of Jesse or you, has been impacted. And I hope that you will, at some point, take the time to read through those to get an understanding of that.
I will, Your Honor.
Thank you for that. And I especially want to point out that Mr. Woodward did write a very lengthy, detailed statement about what he observed that day. And I do hope that that's also been shared with, I think the Sarey family probably would have it because in my reading of them, a lot of them came at the request of the Sarey family. Okay. So I have long ago, well, not so long ago, but over the weekend, and during the course of this week, prepared remarks for this hearing, and I have, as more information came in, changed those. And then today, early this morning, very early this morning, added some additional remarks. So please forgive me that my presentation isn't as smooth as I had hoped it would be, because I do have some changes and some different thoughts in light of the information that's been provided to me today on both sides. One of the most difficult things that a King County Superior Court judge does, and typically on Fridays, is to hold sentencing hearings. Often, at least now, most of those are agreed upon sentencings where the court's function is mainly just to ensure that justice is done based upon the agreement of the parties. Many of those come through plea agreements where there was no trial by jury or judge, but agreement by the parties and accountability taken by the defendant as to the actions that occurred, the crime that occurred, and the appropriate punishment. On those days, in those cases, sentencing, while difficult because you are still changing and altering the course of lives of many, is a lot less complicated than what this court finds itself in today, the position this court finds itself in today. As alluded to by everyone in this courtroom, this case has been pending for a long period of time. This court has presided over numerous proceedings for the last 4.5 years. I've heard from and read thousands of pages of motions, pleadings, declarations, depositions. I've seen that video more times than I care to remember. I've seen it in high def, low def, micropixels, micropixels, mini pixels. I've heard every angle of it discussed, and still it remains a point of high controversy to all. I have been an attorney since 1996 and a judge for more than 15 years, 8 of which I've spent on this bench, and many of which I was a prosecutor before. I've been involved in cases that involve many aspects of the criminal justice system, from representing people to prosecuting them to sentencing them. This has by far been the most difficult case that I have ever been involved in. I would like to say probably for most of us that were involved in this case, it has been. But we are here today to come to resolution and to enter the final stage at this trial level of what is to occur, and that is sentencing. The court, in coming to its conclusion, must first give those who are appearing a little bit of background so that you understand the framework and the context in which the court has used to reach its decision. To begin with, the Washington State Legislature created and sanctioned the Sentence Reform Act to create uniformity in sentencing of a person convicted of similar offenses with similar criminal history. In doing so, the goal is that crimes are assigned a seriousness level, and a person's standard range is based on their prior criminal history. From there, standard range of sentencing is applied, and points are applicable to that criminal history. In this matter, on June 27th of 2024, after hearing testimony over weeks and deliberating over days, the jury of 12 of Mr. Nelson's peers found the defendant guilty of 1 count of murder in the second degree and 1 count of assault in the first degree. As to counts 1 and 2, the seriousness level nor the standard ranges are all agreed and are not in contention. For the murder 2, it's a serious level 15 offense. For the assault 1, it's a serious level 12. His standard range on the murder in the second degree is 123 to 220 months, and the standard range for the assault one is 93 to 123 months. The defense is asking for and requesting an exceptional sentence downward from the minimum standard range of 93 and 123 months to 78 months on each count, which would be a downward deviation on both counts. Let's begin by first discussing the defense motion about whether this is a matter where the assault one and the murder two merge, and that would require that the court find that there's double jeopardy and vacate count two. I want to begin in my analysis of that, of pointing out the instructions in which the jury were given for each count. To convict defendant Nelson on count one, the jury had to decide that the state had proven its case beyond a reasonable doubt as to the murder two, that on or about May 31st of 2019, the defendant committed the crime of assault in the first degree, that he caused the death of Jesse Sarey in the course and in furtherance of that crime, and that Jesse was not a participant in the crime of assault in the first degree, and that these acts occurred in the state of Washington. The assault in the first degree that the state elected throughout its presentation from, and its theory throughout this case has always been that the murder two was based on one shot, and that is the shot to the abdomen. And they made that clear as to the second count, count two, assault in the first degree. The jury had to find that on May 31st of 2019, the defendant assaulted Jesse Sarey, that the assault was committed with a firearm or by force or means likely to produce great bodily harm or death, and that the defendant acted with intent to inflict great bodily harm. I will point out that that account of the assault there is the second shot, which is the shot that was to the head. What this court recalls, and I want to point out that I did go back and review my notes from the testimony from the medical examiner, is that my recollection and my understanding of my notes were that the medical examiner couldn't necessarily declare exactly which wound ended Jesse's life, but most certainly had concerns that the laceration of his liver caused by the first one was harmful enough that it likely would have caused a loss of life, regardless of whether the first shot happened or not. And as I reviewed my notes, that the second shot, given where the bullet landed, would have also more likely than not caused brain damage. So independently, the assault injuries were independent of each other would have. Now, turning to the legal standard here, defense argues that under the Villanova case, that the fight that ensued, meaning from the time that Officer Nelson indicated to Jesse that he was going to arrest him until that final shot, was one continuous action, and argues that because of that, and looking at the factors, the 5 factors, which for lack of time I had written to go out, but I'm not. They have been articulated in the briefing. Both parties have articulated them, so I'm just going to go straight to my findings on them. So what this court does find in looking at those findings is that those acts were separate and apart, and that when you look at the case law and how you assess whether or not they're separate, and even the Villanova case, there were 2 separate incidents. And yes, it was quick and fast paced, but there's 2 distinct situations that happened. We have the first situation where, and I think Mr. Calvo said it best, this is where I added notes here. where Officer Nelson violated his training on the time, distance, and cover, and that led to the first engagement. Now, I do want to point out something that the prosecution has not really touched upon, which the court wants to touch upon, and that is the witness statements make it clear that there was some type of mutual combat that was happening there, and I don't think that we can dispute that. One of the witnesses described, I think it was Mr. Woodard, as it was Tasmanian devil, and even when he was speaking at the scene, he even said to Jesse, just stop resisting, just stop resisting. So I say that to point out, not that I'm at all blaming the victim here. I want to make it very clear that in making that finding, I am not blaming Jesse for his death. And I think there's a distinction that needs to be made there. But as I will talk to later about the defense, the failed defense that's allowed under the SRA regarding a failed defense and when you can ask for mitigation on that, or should the court look at that? Because it's a defense that rises to this event, but it failed, which here I'm finding that it is a failed defense because the jury clearly did not agree that this was self-defense. Yet, in this court's having sat through all of the information and reviewed that, there is some mutual combat that took place during some period of time before that second shot. I want to make that clear, before the second shot. So that addresses the court's finding as to one of the reasons why I think that this does not fall under a situation where double jeopardy would apply. The other is the distinction that this court sees, which is there was a point in time when Officer Nelson, albeit for how many, a heartbeat, 2 heartbeats, 3 heartbeats, 3.2 seconds, did, and as was acknowledged by witnesses on the scene, stop, and by his account as well, did stop. His training told him that he was to look around, assess the situation, see if the threat still existed. At that time, Jesse Sarey was laying against the ice cooler. And what we know from the coroner's testimony, according to my notes, is that when that second bullet hit Jesse, what stopped it from going through his body was that it hit the ice cooler. That's the first bullet. I'm sorry, I may have misspoken there. But it hit the ice cooler because my notes, when I looked at what the coroner had to say, the medical examiner, he said that the bruising that was seen on the back of where the bullet landed was consistent with that bullet hitting a hard surface to keep it from penetrating the body. And the only thing, based on where Jesse's body landed, that could have been was that ice cooler that he was against. So he's laying against the ice cooler. He's been hit by the first shot. Then Officer Nelson has the opportunity to, if according to his training, when his gun jammed, take time to tap, rock, and assess the situation. We know that he assessed it because we know, according to Stephen Woodard's testimony, that he turned around and he looked at Stephen Woodard. He looked back to see what was going on. He took the time to clear his gun, and then he still fired the second shot into Jesse's head. It will remain always disputed between experts here, and I want to point out that the only expert that testified in the trial was the state's expert, who said that Jesse was falling away at that point in time and did measurements about the distance between where Jesse's head was and the video, and that he would have, based on those measurements, been falling away. And so to the extent that defense wants to say that their experts said otherwise, and while I can acknowledge that this is a point of contention between the parties, the testimony in the trial and what the jury had to hear and rely upon was that Jesse was falling away. And at that point in time, I want to also say, to the extent that, and so that addresses that. I do not, and so I do think that the motive intention, because there was time to tap breast assess, and he still shot the second shot. I do not find that on a legal basis, when you look at the 5 factors as laid out in Villanova, that this is a situation where double jeopardy or merger applies. So therefore, I am not going to vacate count 2. Again, I will say that this is heavily briefed by the parties. I had intended to go into much more detail, but it's there. And so, as I know this case will go to the Court of Appeals, I want the Court of Appeals to know that I took into account everyone's arguments, everyone's position, and I'm just at a high level trying to articulate the facts that I see in this, bearing in mind that the arguments are very well articulated in the briefing, and that I just don't find, based on the factors, that the defense's argument is appropriate for there to be a merger and double jeopardy to apply. Now, as far as the defense's argument for factors for a downward deviation from the standard range, as pointed out, there is a legislative intent and expectation that similarly situated people committing similarly situated crimes will be sentenced to similarly situated sentences. The defense here, and let me back up a bit to point out another piece of this, and that is, as pointed out by the defense in their briefing and by the state today in argument, there is no precedent for what we're doing here. This is the first time that this case was the first case filed under the new RCW. It is the second case to be tried, but it's the first conviction of a police officer. And there is no precedent for what a similarly situated, as far as what sentencing, that hasn't been tested yet. This will be the first case to which the courts of appeal will have an opportunity to look at the new law and the issue of sentencing. What I can say, and what this court has taken into consideration, is that this change in the law, which I will talk about in a few minutes when I get to the statements from support, the community statements, is a change in the law that was brought about by community outreach and by issues that the community saw as being an abuse of police powers for many years. Yet, this is the first time a police officer since 1938 had been tried for any type of crime. And as I stated, it's the first time that this law has been tested. What's important about that is to know that this was a legislative change that was brought about by the will of the people. The community voted on this through I-90 and overwhelmingly passed it, which then changed the law and removed what had been, from prosecutors' points of view, a barrier before, which was the issue of malice. It also attempted, from what this court can tell, and as addressed in my previous rulings when I ruled on the standard, addressed when and where it's appropriate to use the objective versus subjective standard in looking at an officer's actions, and that it is appropriate to look at their training when we're looking at what a reasonable officer would do. Given that I know, and it is a record that the legislature, based on the vote and the will of the people, changed the police accountability statute to make this something that could be prosecuted, I also have to look at the fact that the legislature is responsible for the SRA, and they did nothing to change the SRA as it comes to police officers who are charged. So that means that, from this court's point of view, the legislature intended for the courts to imply the standard ranges as they apply for whatever charge that police officer is charged and convicted of. And in this case, it's murder 2 and assault in the first degree. I already stated those standard ranges. So then I also looked at the fact then that means since the legislature didn't create a special scheme for sentencing officers who are convicted under this, then the legislature must intended for this court to apply any type of deviations that would be applicable to anyone who is convicted of those crimes. So with that, I looked at the factors that the purpose of the SRA, the factors which the defense discussed in their briefing, the factors that are laid out in case law about what is and is not a mitigating factor, and that really is what we're looking at here because the state, no one's requesting a mitigating, a deviation up. The case law makes it clear that when looking at mitigating factors, the court, the fact that a person should not deviate from a standard range merely because the court believes that the range is too low or too high, and that a lack of a prior record is not a mitigating factor to deviate therefrom. That when looking at whether or not a person would reoffend, that alone is not a mitigating factor. As argued in this case by defense, this crime is one that is related to Defendant Nelson's employment as a police officer, so the likelihood that he would reoffend, the court should consider that. And again, I don't think that when I look at the fact that others who have not committed, that's not a reason to mitigate. I should not take that in account in this case either. The case law says that the court can look at whether or not the victim provokes an assault as a mitigating factor, and that the failed defense of use of force, unlawful force, is a mitigating factor. Those are two things that the defense has asked the court to look at as far as why this would be an appropriate mitigating factor, in that the court should deviate from the standard range and give Defendant Nelson 78 months. However, the court must also balance that against the SRA and its purposes, and taking into account the nature of the crime. And this is not the nature of the crime. So under the RCW, specifically RCW 94A010, there are 7 articulated reasons for what the court must look at when deciding whether a sentence is appropriate or not. The first one is to ensure that punishment for a criminal offense is proportionate to the seriousness of the offense and the offender's criminal history. The second is to promote respect for the law by providing punishment which is just. The third is to be commensurate with the punishment imposed on others committing similar offenses. The fourth is to protect the public. The fifth is to offer an offender an opportunity to improve him or herself. The sixth is to make frugal use of the state and local government's resources. And the seventh is to reduce the risk of reoffending by others in the community. So when I look at those factors, I then started taking into account the letters that I received from Mr. in support of Officer and Defendant Nelson and Mr. Sarey, and the type of people that they were. I will say this, and even in the words that are spoken today by his friends and family members who clearly and dearly love him, it is clear that you do not agree with the decision of the jury, but the jury must be respected. Their decision must be respected. And they have made a decision that his actions were not lawful, and that must be respected. I also want to point out something that I found very interesting, and that is, Ms. Murray, you indicated that this was that the state wanted to look at this as one-sided and was about what Nelson did and not take into account what Jesse Sarey did. what I would say to those who are here in support of Officer Nelson, you too are one-sided. What I continually heard was that he's a good man, that there's not a bad bone in his body, that he doesn't have a mean bone in his body. The videos are not accurate, the evidence about his actions and what occurred that day. That the prosecutor is attempting to obtain an unfair representation of who he is. That he's a man of integrity and honor. What I say to you is that the court would find your statements more credible if there was some acknowledgement of things that this court knows. And what this court knows about then Officer Nelson is that he had a propensity to alter police reports in ways where it appeared that things were not as they seem and that his version was the more truthful. When I look at his own words tell me who he was. When he, in a police situation involving youth of color, specifically says to his partner, "Do you want to F them up? I want to F them up." If he is such a professional and a man of integrity, wearing an Auburn uniform, police uniform, which a badge, having sworn an oath to protect and serve, which applies to all people within the community, particularly those of the most vulnerable, how is that professional? How is that a man of integrity? And to those who would say that he has had a bad day, I agree. We all have moments when we are not professional. We speak harshly to someone. We aren't on our best behavior. There is a difference between speaking harshly and intentionally wanting to harm someone when you have taken an oath to protect and serve. That is not a bad day. That is not given stress. There's a quote that says that, and I want to be specific because I found this and I thought it was very applicable to the situation. Again, I apologize. A lot of notes up here. If you want to test a man's character, give him power. In this situation, I would add, give him power, badge, and a gun. Character is who you are when no one is looking. When Officer Nelson thought that no one was looking and that no one, because of his good deeds that others knew about, would question his integrity, he took the opportunity to harm others. Those are his words. Those are not the words of the prosecution. Those are out of his mouth. And again, those are not situations where he was having a bad day and he was stressed out and yelled at someone or falsely accused them of speaking harshly to them. He said, "I want to F them up." He is a police officer. He said and admitted he wanted to commit the crime of assaulting someone. That is who his character is. With great power comes great responsibility. There's no greater honor than to serve those in the community, and I would dare say, particularly those who are vulnerable, as Jesse Sarey was. And you can tell a lot about a person and how they treat the most vulnerable among them. That being said, this court, in the words of your own attorney, has a very difficult time with trying to fit together two pieces. And let me tell you why. As I read materials about who the man Jeffrey Nelson was, I learned that you're 46 years old. I did not know that. I knew that you had served in the military and that you had joined the Auburn Police Force. I know that you've had extensive training on how to interact with those who are involved in crisis. I learned that you've experienced the unthinkable loss. The loss of holding your 9-month-old daughter as she passed away in your arms. I cannot imagine what that does to someone's soul. And I know that it touched your soul because I read letters of how when you had colleagues who were experiencing that same situation, you reached out to them and you were there for them and you understood. And sometimes it just meant that you just sat there with them and let them quietly express their pain that only someone who has lost a child can absorb. I found out that you are a cat lover and a cat parent. I wouldn't have pictured that, but you were. And that before meeting your now wife, you were a bachelor who lived off of gummy bears and beer. You're described by your colleagues as being the most empathetic, sympathetic, patient, selfless, courageous, kind man with respect for community, who from 2010 through at least 2020, and it may have gone on even to last Christmas, I do not know, the letter that I read stopped at 2020, purchased Christmas gifts for children and families in the community who were experiencing homelessness. That you spent 30 minutes convincing a federal veteran not to walk off the ledge of a building because suicide would devastate his family. That you coached another fellow officer in giving assistance to a transient man who was experiencing a mental health crisis instead of arresting him. I learned today that you purchased a bus ticket for someone that was homeless. I learned that many of your fellow officers felt that if their family was in crisis or they were in crisis, that you are the police officer they would want to respond. And I personally observed that you were a man who on some level respected authority, because whenever I entered or exited this courtroom, throughout every proceeding you ever attended, you stood for me as an officer of the court, regardless of whether I was in robe or not. So much so that I had to remind you if I was just coming out and wasn't in robe, you didn't have to stand. So imagine how difficult it is for me to understand why and how it is and how things could have been different if that was the man that Jesse Sarey encountered on May 31st of 2019. But that is not the man that he encountered. Instead, Jesse, a young man clearly in the midst of mental health crisis, encountered an egotistic Officer Nelson. This is the same Officer Nelson who was seen by John Winterhawk and his friends. And again, I had written more about this, but for time, I'm not going to go into details. It's all in the briefing and in my 404B ruling. Or the motorists, as alluded out, and the others to which the court found that your actions displayed patterns of excessive force. In the words of someone today, and then again, in your own words, you take the biggest and the baddest, and I'll leave the rest. You know what you said. Again, these are not the words, and this is the person that I read in those statements is not the person that your words and your conduct have shown you to be in situations. And again, this court says this and wants everyone in this courtroom to remember that history is always written by the victor, meaning that the person who has the most power will always get to portray and determine how the story is written. In the incidents over your 11 years as an Auburn police officer, you were the one with all the power and all the control. We know of many incidences where you were disingenuous, dishonest, and heard disingenuous, dishonest, and sought to hurt others. We know that your police reports were not always accurately a display of your actions. And because of that, I cannot help but wonder, even though we had that, although it's been argued that this is only a few instances of misconduct over an 11-year career, if we spoke to others who were not the victors in their story, how many of them would have come into contact with the egotistical Officer Nelson that Jesse Sarey saw, the last person he saw, the man who took his life on May 31st of 2019? Since their stories cannot be told. As for your sentencing, looking at the factors that exist, I want to point out several things. One, as I pointed out, the punishment is for it to be proportionate with the seriousness of the crime and your offender history. Based on that, I've already noted your standard range. To promote respect for the law by providing punishment which is just. Respect for the law here goes more beyond you, Officer Nelson. This is the first case in which a police officer was charged, and it in some ways serves as a telescope for others to view police conduct and for police to remember to abide by their training when engaging in situations so that they do not become lethal to them or the others that they are sworn to protect and serve. The third piece is to be commensurate with punishment imposed by others who are similarly situated. And those are my words, it's a similar offenses. As pointed out, no other officer has been involved in this. The court has no guise, but what the court can say is that, as I pointed out before, the legislature has not changed the statute to any way reflect that there should be any changes for an officer who is charged and convicted with these offenses versus a normal person. And so in this court's view, based on that, then the range is the range unless there's a mitigating circumstance to which the court should give a downward deviation or departure to protect the public. Defense argues that the fact that you will serve time and you will serve all the time that the court imposes because you will not receive credit for the time that you spend on home detention, and most of it will be served in solitary confinement, and that this was a crime that was a result of you wearing, happened in line of duty, and therefore the public would be protected no matter what the court does. But that is focusing only on one piece, and that is your part in this. And yes, to the extent that no matter what this court does, you will be away from society for a very significant amount of time. And you will never have a gun or a badge again. Does protect the public, no matter what the court sentences. Ability for you to improve yourself or others, again, I really thought hard about what to say about that factor, and I don't even know what to say because there is something broken in any person that wishes to harm others just for the spite of it. And your own words tell me that there's some piece of you that is okay doing that because, again, why else would you say wearing a badge, when you're wearing an Auburn police uniform and a badge, I want to F them up. Let's F them up. Make frugal use of states' resources and government resources, and the risk of reoffending by others in the community, by other offenders in the community. What I say is when I look at the community here, I look at the community of law enforcement, and specifically, I look at the issue that today and always there's been a large number of officers of Auburn PD who honestly, I would take your statements more credible and I would give them more weight if you at least acknowledge that this man has a past that is not consistent with the person you saw. Not one single person did that, and the videos speak for themselves. So that tells me that the Auburn Police Department will stand by anyone and everyone as long as they have a badge and a uniform. Because you didn't even acknowledge, if I'd heard a family member, a police officer, the assistant chief acknowledge that you missed it, that when you were giving him the awards and giving him the award of valor, that you missed that he had told people that he wanted to F them up. He wanted to, that is significant to this court. And the fact that you continue to stand by him, knowing these things. And again, that is not the state interpreting a video or asking the court to interpret videos or statements. That is your former colleague's own words and own actions. Did you even watch that video? Are you okay with that? By what you said today, it seems that you are. That's concerning. Leslie Cushman was someone that was heavily involved in the creation of I-940, which became RCW 9-16040. And I think Leslie Cushman says it best when in their statement they said that the law addressing the misconduct of the police was substantially modernized and improved, and how an officer's conduct or discipline prior to this date is not a good benchmark at all. And that, again, goes to the marks I just said. In this instance, the jury had all types of information before it. They had information and had to determine, they had reams of information on your training records. They had reams and days of testimony about the video and how to digest it. They had testimony from experts about your training and that you had been trained to de-escalate. And there's no dispute that Jesse Sarey, at the time of this, was in mental health crisis, and that he had an underlying mental health issue and substance abuse addiction. Yet, in spite of all that, they found that you failed to follow your training, that you failed to de-escalate or do something else in a situation. And it's also undisputed that Jesse, at the time you encountered him, was not engaging in the behavior of being in traffic or in any way a danger to himself or others. He wasn't stealing something from the store or causing havoc. He was sitting sitting against the refrigerated ice chest, going through a box looking for something to drink and eat. The law that the people voted for and wanted to hold police accountable for is about this type of situation. Before I give you your sentence, though, in reading my remarks, I skipped over something very important that I wanted to address, and that is something that I think is so very important that often gets looked over, and that is, who is Jesse Sarey? I want to point out that I learned a lot about Jesse in reading comments. I learned that he had a nickname, a Jungle Book Jesse, that he had a very kind soul, sweet. He was a bit shy, excuse me. He was a favorite uncle to his nieces and nephews who loved it when he would body slam them. His laugh was so ugly it made others laugh. He was happy, he was goofy. He had a paper route with his cousin as a kid. He loved WWF wrestling, martial arts, and had a serious crush on Selena Gomez. He was an unfortunate, what I know from the evidence is that he was an unfortunate soul who suffered from mental illness and attempted to self-medicate using recreational drugs. What I find interesting, and something that came to me as I was listening to others speak, I knew this about Jesse, but this quote came to me as I was listening to the testimony of others. I knew that his family were refugees and that they had come here. What came to me is the irony is that his family came here seeking a better life, chasing the American dream, but what they discovered was the American nightmare. The children found themselves in foster care. Jesse himself found himself with a significant mental health issue and lack of resources, having to medicate with recreational judges, and the worst of the worst for every brown, black person of color. He died at the hands of the police. That is the American nightmare, not the American dream that his family sought when they moved here. So with that, your sentence. I want to first also acknowledge, sorry again, my notes are a little bit everywhere. Something else, I want to thank all of the people on both sides who gave statements. I did read them all, and I appreciate the insight that was given to the court. Ms. Simons, I wanted to personally, before I render the sentence, speak to you, and I want to say to you, I've had a note up here on my bench throughout this trial, and the sticky note says, "The mother that sits alone." You have made every court appearance except for one over the course of these years. Every single one except for one. Throughout every continuance. There were times we were here ready to go when the court came on the bench and said, "I got to continue it." You came back, you came back, you came back. There are times that the court would be full on the side of supporters for Officer Nelson, and you and your advocate were the only people other than the prosecutors who were here making sure that someone knew, that this court knew, that the jurors knew that Jesse was real and he was a person and his life mattered. Thank you. I cannot imagine what this has done to your soul. I hope that today you can find conclusion in knowing that Defendant Nelson, who was formerly Officer Jeff Nelson, will be sentenced, and this case can move forward to the Court of Appeals. No matter what I do to you and Jesse's family, I cannot bring Jesse back. There's nothing, no matter what I sentence Defendant Nelson to, that will take away the emptiness and the pain that you feel. But know that your commitment to his mother, to his family, to see this to the end, did not go unnoticed. I will also say to Officer Nelson's family, despite how the court weighs the information given you, I do respect that you showed up every day, particularly your wife. And you sat through testimony, again, just like Ms. Simons, through continuance after continuance, you continually showed up to support your husband. I also want to recognize something that I appreciate that Officer Nelson's wife did, no one else did from the defense's side, and that Ms. Simons did, and that's acknowledge that this tragedy impacts everyone. Officer Nelson has a young daughter. I don't know how many know that. He has one that passed away at 9 months, but he has another one that survives and is alive. And she will not be able to have significant time with her father where they will do father-daughter dances or any of that while he is incarcerated. But I also want to remind people that Jesse's family will never hear his laugh again. I've not really heard acknowledged from those who spoke on behalf of Officer Nelson. Sophia still gets to see her dad. The Sarey family will never see Jesse, and they will never see the members of their family that were lost due to the heartache and trauma that this has caused them. All right, your sentence. So, in the state of Washington versus Defendant Jeffrey A. Nelson, on the count 1 of the charge, which is murder, in the second degree. The defense asking for mitigation downward of 78. The state asking for the high end of 220 months. The court will impose 200. I will explain, I am giving a deviation, not a deviation, but I am not doing the high end only because I am acknowledging what is, and I've gone back and forward with this. That by not giving you those extra 20 months, I'm acknowledging that there was some part of you during the initial struggle that was engaged in a struggle, and I do think that that accounts for some level of a failed self-defense. And so, but I also fought hard and thought hard about it because of the fact that you are a person that is not similarly situated to others with that 220 because you were a police officer. You had a duty under the U.S. and the Washington State Constitution to protect and serve. That being said, I absolutely have to acknowledge that there was some period in time and when there was a struggle before the second shot in which there was some mutual combat going on. I am not doing the low end, nor am I doing truly the mid-range because I do think that unlike others, you were a police officer and that's different than the standard murder in the second degree. On the count of the jury having found you guilty on the count 2 on assault in the first degree, I will sentence you to the 123 months. That will run concurrent with one another. I do not find that you were indigent because I have no information to support that, so I will impose the $500 victim penalty assessment. I will impose restitution if the state wishes to seek restitution. The state has 180 days, meaning 6 months from today, via his counsel. Defendant Nelson has already waived his presence at that. However, because of the nature of these offenses, I'm required to require firearm registration as part of this, as required by the statute. Following your release from confinement, you will be placed on 36 months of community custody. Because these are felony convictions, you will lose your right to possess a firearm. That is a prohibition that remains in place until it is reinstated by a court order. You will lose your right to vote. I am, by agreement of the parties, entering a no-contact order with the Sarey family and with Ms. Simons. I believe, and the court, via your counsel, once your counsel goes over the advisement of rights, I will advise you of those on the record again, because you do have rights of appeal since this was a matter that went before a jury of 12 who convicted you, so you do have all of your appeal rights that remain in place. I believe with that, Ms. Eakes, I have addressed our,
Just, Your Honor, I may have not heard you, but is Stephen Woodard included in it?
oh, yes, and Mr. Woodard as well is included in the lifetime no contact order. I believe with that, I have addressed all of the conditions of sentence. Have I missed anything?
No, I think that you covered everything, Your Honor. I do think maybe you misspoke. You said about firearm registration. I think you meant DNA registration.
Oh, sorry, yes. DNA, sorry, DNA,
no
yes. It's a
worries.
felony, and so you will be required. There is no longer under statute a $100 assessment of that, but you will be required to give a DNA sample.
Thank you.
I do want to point out one question I did have for the state, though, and that is the firearm offense. I do, because it's a felony, it was under the new RCW 9413330. Because of the nature of these, I think I am required that he do the felony firearm offense. That's the statute 9413330, because the
Our
nature.
understanding is firearm registration. Is that what you're talking about, Your Honor?
That's, yeah, it's called firearm registration offense. I think that that is mandatory given the
Correct.
nature.
And
So,
I've supplied the defense with that form.
yeah, and so that will be part, I didn't say that, but that will be part of the court's order.
Your Honor, I've completed the judgment of sentence in accordance with your oral ruling, and I'm going to hand it to the defense for review.
You will also be required to provide your fingerprints. Hopefully, we have the ink pad down there for you to complete the fingerprint form.
We did that. Yeah, we already did it. Yeah, yeah.
For those who are present here in the courtroom, we have a substantial amount of paperwork that we'll be completing. I'm going to ask if anyone wants to leave the courtroom before that's completed, that you do so now. Otherwise, I'm going to ask that everyone stay until I release you. I'll be releasing people in stages.
Your Honor, we did prepare and sent to the defense yesterday a proposed order on findings of fact for the order on the new trial and for recusal. So I'd like to submit that to the court at this time.
And Your Honor, with respect to that, I do have something on the JNS, but with respect to that, we haven't had a time to look at that.
So what I'm going to say, that this is going to be a proposed order. I think that we need to, if you guys can come to agreement on what the word is, the verbiage, then I'll sign off on it. If not, we'll do another
Okay.
quick hearing. I also, as I was going through materials, realized there were a couple orders that we spoke about that I cleaned up, but in light of everything that happened, never got filed.
And the other issue, Your Honor, is we did send to the state yesterday, we have a motion to seal an email between the parties and the court regarding a continuance that happened right before our trial for an unforeseen circumstance.
And we have no objection to
Just to
that.
complete
Yeah,
that.
yeah,
So
yeah,
we
yeah, yeah, yeah,
need to
yeah.
clean that up as well. So we can send that to the court. Sounds like
Yeah, there's some cleanup things that we need to do. Certainly, like I said, when I was going through, I found a couple of orders that we spoke about that I saw I didn't file, so there's some cleanup things we need to address.
And Your Honor, one other thing, just going back to the Zoom interruption that we had, one thing that I did not see, but one of our staff did see, is that we wanted to make clear it was anti-law enforcement pornography, and so I just want to put that on the record.
Okay, all right, I did not see the nature of it, I just saw it was graphic, but thank you for,
Your Honor, yeah, have no idea what kind of
yeah,
pornography it was.
I have no idea.
From the state can concur that it was of that nature, but we don't know.
Yeah, all, we know that it was very graphic pornography, and so we've made a record.
Going back to the judgment and sentence, Your Honor, on the no contact order, we've got Elaine Simons, Matthew Sarey, Stephen Woodard, and Colton Hart, Mr. Sarey's younger brother. It also says the Sarey family. That's not very specific. I would ask that that be stricken.
Right, so the named members that, and I said the Sarey family, meaning the people that I knew were named, Matthew, Colton,
Oh, I just crossed it out. That's fine.
and then Mr. Woodard, Ms. Simons.
Would it be too much to ask if I could run to the restroom really fast while this is being done?
It's been a long morning.
I'll be right back.
Your Honor, I'm actually done if the court.
Well, I need to look at it, so before I do anything else, we'll wait for Ms. Eeks and Mr. Kaufel.
I'm still here.
Okay, there's still
okay.
a lawyer.
Okay,
here, so
there
I can
is
talk on
still
their-
someone from the state here, okay. To,
Okay. Here, I can tell it.